Committee will come to order, and the clerk will please call the roll.
You have a quorum, Mr. Chairman.
Thank you. We've got a pretty full docket, and I want to first announce or get a motion. There are 5 bills that have been requested to go by for the week, and those include SB 988, SB 1026, SB 1108, SB 1222, and SB 1227. That was 988, 1026, 1108, 1222, and 1227. Can I have a motion that those go by for the week? Okay, and all in favor will say aye. Aye. Any opposed? Okay. Now we have some bills that need to be re-referred with separate motions. The first is SB 1034 from Senator McPike, needs to go to courts. Okay, all in favor of referring SB 1034 to courts will vote aye. Okay, next we have SB 1094 from Senator Norman to be referred to Finance. Okay, all in favor will vote aye. Referring 1094 to Finance. And next we have SB 1127 from Senator Morrissey to be referred to Rehab and Social Services. Is there a motion? Second. Moved and seconded to refer SB 1127 to Rehab. All in favor will vote aye. Okay, we've got 2 more. Next is another of Senator McPike's to go to local government, SB 1141. Is there a motion to refer SB? Okay, moved and seconded SB 1141 go to local government. All vote aye if you're in favor of that. Any opposed can vote no. Okay. And finally, from Senator Reeves, we had SB 1208 about the Virginia-Taiwan Trade Office to refer that to Commerce and Labor. Is there a motion to do so? Second. Okay, moved and seconded. So all in favor of referring 1208 to Commerce and Labor will vote aye. Any opposed vote no. Now, if we could just keep up this pace, we'll be done in no time. We have before I get to the sign-up list, I want to announce that we have a gaming subcommittee. I'm going to remove myself from the gaming subcommittee and in my place appoint Senator Locke, and in the place of former Senator Kiggins, appoint Senator Reeves. So that would be Senators Locke and Reeves joining the gaming subcommittee. And then we come to the sign-up sheet with Senator Favola as our first patron of SB 1060. Senator, welcome.
Thank you, Mr. Chairman. This will, I hope, will be your easiest bill of the day. Basically, this is an administration bill, and what it does is anybody who has requested or applied for a license, and they have an application with the Bureau of Health Professions or the Department of Professional Occupational Regulation, it would allow that applicant to access any information in his or her application file through electronic mail, email, or through snail mail. Right now, the current law requires the individual to go in person to get information that's actually in his file. And that's a hardship for folks. Applicants don't understand why. They'd like information from their own file emailed to them, and or snail mailed, and then of course the applicant would pay for the snail mail. That's the bill.
Thank you. Are there questions for Senator Favola from members of the committee? Okay. Are there members of the public who would like in the room who would like to testify for this bill?
Those in Zoom who would like to speak in support of this bill, please raise your hand electronically.
Did you want to speak, ma'am? Come forward and introduce yourself.
Mr. Chairman, members of the committee. Erin Barrett on behalf of the Department of Health Professions. This was our request. We strongly support this bill. This would be a common sense change. We have a lot of applicants that ask this, and they don't understand why we can't provide information in this way.
Thank you. Is there anyone in the room who wants to oppose this common sense change? Okay. Andrew, do we have anyone in Zoom who wanted to speak?
There are no speakers, Mr. Chairman.
Okay. Okay, it's been moved and seconded that this bill, SB 1060, be reported. All in favor will vote aye. Any opposed, vote nay. Okay, thank you, Senator.
Ayes 14, no zero.
Okay, our next senator in the queue is Senator DeSteff.
He's over at court.
Okay, so we'll skip over him temporarily if Senator McDougal is here. I think he and Serville are probably both in court. So is Senator Cosgrove in the room?
He's in court.
Are there senators not on the committee in the room who have a bill? Okay, who's on the committee who's got a bill? Like Sarah Bell, why don't you go first?
Is that all right?
Sure thing.
Thank you, Mr. Chairman. You want to go into order 891? I think it's the lowest one.
91. This is on page 4 of our agenda, Senate Bill 891.
Mr. Chairman, it's a fairly simple bill. I'm carrying it at the request of the realtors. This is during the pandemic. As you know, we unfortunately get to move into our wonderful new offices because we couldn't get in all the materials needed to complete the building, and we've had a delay of getting materials in. This has actually led to a problem in returning deposits and following the law. So this, because they really couldn't, if there was damage to the property, they couldn't get the estimates and materials to make the repairs within that time frame. So this bill would increase it from 15 to 30 days, provides additional time. We don't believe that this is something we need to do long term. So you'll note the bill sunsets on June 30th, 2024. And the hope is by that time, these supply issues we're facing today would be gone. And the hope is here to basically put landlords who are trying to do the right thing not in a position where they would violate existing law due to things that are beyond their control. With that being said, I'm happy to answer any questions you or the committee have.
Senator, this is just for bills that have damages being itemized, right? Just for deposits where the tenant has damages that are to be itemized. If they don't have damages, it shouldn't change the time frame significantly.
Mr. Chairman, that's exactly right. It's with the itemization of damages to premises, the cost of repair when such damages exceed the amount of the security deposit. In those cases, that would be where you might need to get estimates and repairs that would cause that delay.
Okay. Are there other questions from members of the committee for Senator Bell? Are there members of the public in the room who'd like to speak for this bill?
Good afternoon, Mr. Chairman. Erin Corman with the Realtors. I would like to thank the Senator for bringing this bill on our behalf. We obviously support the bill, and I'm happy to answer any questions that anybody has.
Thank you. Hi, come forward.
Good afternoon, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We also support the bill.
Anyone opposing the bill? Okay. Andrew, are there any in Zoom who would like to speak on this bill?
Those in Zoom who would like to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, it's been moved and seconded to report SB 891. All in favor will vote aye. Any opposed will vote no.
Can you vote? I don't know if you could transfer it. I actually have a couple proxies as well.
I got you, sir. Just a second. It's on it.
There we go.
Ayes 14, no zero.
Okay, and you have two other bills, right?
Mr. Chairman, the next bill is SB 1024. This is an administration bill. I was asked to carry this. This is basically there was a loophole we found it's when there are records that normally would be open to public disclosure, but the problem is we found that some records actually contain HIPAA or FERPA privileged information that's protected, and there was a loophole where that information would not be protected. We want to make sure that we protect that information. If they were things that were, for instance, in the Library of Virginia or held as confidential working papers that could be released, we want to make sure, again, that people's personal, private, sensitive information is not protected, and just give these records the same protection provided in other areas of law. With that, I'm happy to answer any questions that anyone might have.
I had a question for counsel. This bill, it seems pretty common sense, but I'm just wondering, the way it's worded, it says they shall remain, that these records shall remain confidential by law, shall remain so after being deposited in the archives. Does the next sentence, all records deposited in the archives that are not made confidential by law shall be open to public access? Is that sufficient? We don't have to say that they're confidential as long as required by law or anything like that, do we? We're good with the wording the way it is. Okay. Are there any other questions from members of Senator Hashmi?
Thank you, Mr. Chair. Is there any length of time for which they remain confidential? I'm thinking about for scholars and researchers who may be trying to access materials 50 years from now, 100 years from now. I know we're facing that issue with certain records that are archived and that are sealed, and we have some researchers who have been frustrated as they're trying to examine mental health issues as well as medical treatment plans in Virginia, and they have not been able to access those records. So I'm just curious if there's any attempt to make the records open after a certain period of time for research purposes.
Mr. Chairman, I'll attempt this and then phone a friend for the rest of it. My answer on this is normal records in the Library of Virginia are required to be closed to the public for 75 years, and then there's procedures for the release of those records after that. However, these records, since they fall into the HIPAA and FERPA, they follow the law of that, and they're normally kept confidential. So it would probably be against what you're talking about.
Are there any in the room who'd like to speak in favor of this bill? Good afternoon.
Good afternoon. I'm Sandy Treadway. I'm the agency head for the Library of Virginia, and we strongly support this. We thought until very recently that we were okay restricting these records. So we get them especially in clemency files from the governor's office. What we were told by the Attorney General's office that we could, because we're not a covered entity, for example, under HIPAA, we could not restrict them in the way that a hospital could. So we were advised to seek this sentence. And if I may respond to Senator Hashmi's question, the intent would not be to close these forever. It would be for the period, for example, if they're medical records, that they're protected under HIPAA, and then they would be released. And we would not close anything else that was in one of these files. It would just be the original medical or educational records which are protected. So we support open government, and that's what we're passionately committed to.
Thank you. Any others in the room want to speak for or against this bill? Okay. Are there any in Zoom who'd like to speak on either side of this legislation?
Those in Zoom who wish to speak, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. Is there a motion on Senate Bill 1024 if there are no other questions?
Move to report.
Is there a second? Okay. It's been moved and seconded that SB 1024 be reported. All in favor will vote aye.
Ayes 14, no 0.
Thank you, Senator. Did you have one more?
The last one is SB 1071. This is a bill that amends the Code of Virginia to accurately really reflect our intention to be the best state for veterans. And what it does is it allows the Department of Veterans Services to provide mental health and other services to transitioning military service members and in the instance, we found that there was a loophole that those who were transitioning from military to civilian life were not covered. It covered, frankly, people who were in different statuses but not in that transitioning status. And frankly, this is, I think, one of the biggest points of need. A military member transitioning to civilian life could be as related to a medical condition, a medical discharge. It could be related to many other types of separation. And frankly, these services might be more valuable to them at this time than any other. The other thing I would say in this is if we want to encourage veterans to stay in Virginia, this is one thing that will help us to do that. This is also an administration bill. I know we've got people here to speak to it. Happy to answer any questions you might have.
Are there questions for Senator Bell? There's also references to the military spouse liaison in this bill. Is that right? At the end, that they provide a.
Mr. Chairman,
Yeah.
you're absolutely right. The military spouse would also be able to have these services available to them. I will say that oftentimes military members transitioning, the services to the spouse can be critical as well in employment and in other transition-related issues.
Okay. Are there any in the room here today who'd like to speak for or against this piece of legislation? This is SB 1071.
Good afternoon, Mr. Chairman. My name is Claudia Flores. I'm the Director for Policy and Planning with the Virginia Department of Veteran Services. Sir, this is an agency bill, and we strongly support it. Thank you.
Anyone else in the room? Andrew, or any in Zoom?
Those on Zoom who'd wish to speak to this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, there's a motion and a second to report SB 1071 and refer to Finance. Okay, they'd requested this. So all in favor will vote aye. Any opposed will vote no.
Ayes 14, no 0.
Thank you. Okay, thank you, Senator Bell. Now, I think I saw Senator Servell, but before we get to him, Senator McPike had two items of business. I think there's one bill that was referred to the Gaming Subcommittee that's not being heard this week.
That's right. Thank you, Mr. Chairman. Yeah, Senate Bill 780, which deals with the casino referendum, will be passed by for the day in subcommittee. Just if anybody's interested, so Senate Bill 780 will not be heard in subcommittee after this meeting. And then also, Mr. Chairman, I would move that Senate Bill 1143 be re-referred to the Committee on Rules. And that's also in relation to gaming. So Senate Bill 1143.
And is that a recorded vote, or is that we're referring to another committee? I think we have to record that vote. So that's a motion, and I'll second that, or someone else can second that. Okay, there's a motion and a second to refer
Senate Bill 1143.
1143 to the Rules Committee. All in favor will vote aye. Actually, it should just be to refer it rather than report and refer.
Whichever. Re-refer.
Re-refer, okay. Thank you. Okay, and now we've got some other patrons. Senator Servell, I saw you first. Why don't you come, and we'll get to Senator McDougall when you're done.
Thank you. I got Senate Bill 1428.
Okay, 1428.
Right. So 1428 has to do with foreclosures involving homeowners associations. Just for a little bit of background, because I know there's only, I think, one litigator up on the dais there. In 2021, Delegate Torian carried a law had to do with a bunch of housing reforms, and one of the pieces of that law said that you're not allowed to foreclose on somebody's home. You're not allowed to take somebody's house if you have a judgment against them, unless the judgment is for at least $25,000. We passed that in 2021. So if it's like a $10,000 credit card bill, something like that, you can't take their house. Unbeknownst to me when the bill came through, and probably other people, the authority for foreclosures for homeowners associations, condo associations, cooperatives, and timeshares is set forth in a different part of the code. I mean, I knew it was there, but it never occurred to me that that there was this exception, this end run around that $25,000 limit. So HOAs, condos, co-ops, timeshares today can still foreclose, take your house if you're in arrears for your dues for like $100. And I don't think that should be the law. And I believe I don't have any examples I can cite to today. But I've heard there are associations out there that will, in fact, try to take someone's home when people haven't paid that amount. Now, the way you do it is you have to first put a lien on somebody's house. And there's lots of liens out there. The lien is good for 2 years. And in order to preserve the lien or do something with the lien, if the dues aren't paid within 2 years, the association has to file a lawsuit. They have to seek a judgment to enforce that lien. And if once they go to court and a judge looks and says, okay, yeah, you owe the money, then you get a judgment. That judgment's good for 10 years. But the lien itself disappears after 2. And once you get the judgment, then you're in the judgment world and you're subject to the $25,000 cap and all that. But if you don't go get the judgment, you can say, I don't want to go get a judgment. I'm just going to take their house for $200, $500, $1,000. And all this bill says is that you can't use that foreclosure remedy until you have at least a $5,000 balance of unpaid assessments, exclusive of attorney's fees or other expenses. Because you got to understand, it costs probably $5,000 to $10,000 for a lawyer to sell a house over $200 or $500. And so often, these very small owed assessments that could turn into foreclosures basically become a way for lawyers to make money. And I don't think that's right, even though I'm a lawyer. So that's basically what the bill does. It just says that if you're going to use this HOA, condo, co-op, timeshare foreclosure remedy, you have to have at least $5,000 owed. And I'm happy to talk about the number. I just picked the number out of the air because I thought $5,000 was a fair number. Somebody else likes a different number. I don't care. But that's what the bill does.
Thank you, Senator. Are there questions for Senator Surville? Are there?
Mr. Chairman?
Yes, Senator Bell.
My question, how did you arrive at the $5,000 figure? I'm sure that you could pick any figure, but I just think of the price of home in many areas in Northern Virginia. That's still a pretty low percentage of the value of the home.
You know, there's some HOAs have really small monthly assessments and some are really high. I mean, somebody today told me that their condo fee is $1,700 a month. I've seen other HOAs where it can be as low as like $50 a month. And so I just tried to pick a number that I thought was kind of in the middle and was kind of close to the amount of attorney's fees that would be necessary to do a foreclosure remedy to where it started to make a little bit more sense to go to that level of effort. But I don't, if you want to go higher, I don't care. I picked $5,000 because the HOA dues can vary. And
Senator Bell, do you have a follow-up?
My only follow-up is I agree with you that, you know, I think we could go back and forth on the amount. I'd feel more comfortable if it was a percentage of the home value and it got over a threshold, then I think it'd be more realistic to do it. But
that's
I just
another
offer
way
that.
to do it. Yeah, tax assessed value, right?
Senator Mason.
Thank you, Mr. Chairman. So you said the judgment's good for 10, but the lien only 2. Is that something we can adjust and make sure that the lien at least stays for the term of the judgment? I mean, it doesn't really help the homeowners association because they're still not getting their money. The person's still not paying the assessments. But at least it would be on the title and subject to being paid with the sale of the home.
So is the judgment. So if you sue to enforce the lien, then you get a judgment. Then you record the judgment in land records, and that replaces the lien on the property. So the judgment becomes a lien. Plus, you get the attorney's fees and interest and all the other stuff.
Right. Mr. Chairman.
Yes, Senator Mason.
But you don't have to do it that way. You can just lien the property, right?
What they often do today is just the first step is to put a lien on somebody's property, and then send them a demand letter and say, you owe us $500, pay it. Most normal associations after that, if they don't get paid within the 2 years, file a lawsuit. then they go to court and they use the court process. And if they get a judgment, they try to garnish a bank account. They try to garnish a paycheck. You can seize a car and sell it. They try to pay it using the judgment collection process. That's the way most normal places do it. But there's one or two out there that are that choose to forego going to court and instead say, you know what, I'm just going to skip to taking your house. And I'm just not going to go to court. I'm just going to start a foreclosure proceeding because, it's a lot easier to get somebody to pay that way. So that's what I'm trying to avoid, is to try to incentivize people to stick to the legal process unless we're talking about really a big amount of money.
Okay, Senator Mason, did you have another question?
Well, thank you, Mr. Chairman. So, yeah, and thanks for explaining how it really works. But would it do us some good if we can we allow the lien to be 10 years? So they just keep leaning it. You don't have to go and get a judgment. You don't have to garnish either wages. You say
10 years is too long. The point of the 2-year limit on the lien is that it forces you to go to court to get the matter adjudicated, to find out whether you really owe it or not. I mean, sometimes these people don't owe the money. You got to remember, first of all, we're not always talking about monthly assessments. Monthly assessments are kind of hard to dispute, right? The amount of money you have to pay every month. But every once in a while, HOA will do a special assessment on somebody. Say, like, they don't clean up their yard. They'll bring in somebody to clean the yard up, and they'll special assess them for the bill for cleaning up the yard. Where they'll say, your house looks like crap. We're going to fix up the front of it. And then they special assess you for that, right? So those can be also these types of liens. Actually, I represented HOA 15 years ago or 20 years ago, and I used to do these. But most of the time, it's the monthly assessments that people aren't paying. Most of the time. And again, the point of the 2 years is to force everybody to go to court, get adjudicated, find out if we're really dealing with a valid debt or not before you go to 10 years, right? I mean, and so the statute of limitations on this stuff isn't 10 years. It's typically 5 because it's a written contract. And you want it adjudicated before 10. So.
Thank you, Mr. Chairman.
Okay, Senator McPike, did you have a question?
Thank you, Mr. Chairman. Just a question, patron, in terms of you may have spelled out a remedy, but you've taken a different approach in terms of order of priority of instruments or some other means to, like, say, before taking this action, then pursue these acts. I mean, I don't know if that's possible, but I mean, it seems like there's a number of different solutions besides limiting. I just can't. I can see where there's multiple different ways that could complicate the life of different common interest owners that are trying to resolve financial issues that sort of languish and sort of continue on with someone that, as you know, in HOAs, they can get quite combative based on my constituent emails, and sometimes they're right and sometimes maybe they're slightly mistaken. So what other options did you, assess or take a look at?
Well, I think if you were to ask the people that are going to speak after me, what they will probably tell you is that the use of this foreclosure remedy is exceedingly rare for a lot of different reasons. It's a very risky thing to mess around with under the Fair Debt Collection Practices Act. There's a federal statute and some other things. So it's not asserted very often. And so they typically, I think 95% of the time, they probably go to court and sue over this stuff instead of maybe even 98, 99% of the time, they probably go to court and sue over this stuff instead of using this foreclosure remedy. So I thought this was dealing with a very tiny, little, small minority practice that I thought was ridiculous. And so that's why I thought it was a pretty simple solution to the problem. I mean, especially given that we had already adopted, you can't take somebody's house unless there's $25,000 involved as a policy 2 years ago. So I agree there's a couple other ways to go at it, but I thought this was pretty simple.
Okay. Unless there are more questions from the panel, let's see if there's others in the audience who want to weigh in for this bill or against this bill. Those in the audience who'd like to speak for SB 1428 here today, please come forward. Anyone against this bill who would like to come forward?
Senator, how are you doing? Good afternoon, Senator. I'm Pia Trigiani. We represent condominium and homeowners associations. I'm representing today Community Associations Institute, which is an organization of homeowners, developers, builders, management companies, and associations that serve common interest communities across the country. It's a 50-year-old organization formed in Virginia. Virginia is considered one of the model states in legislation in this arena. There's no intention for an end run here. This has been the law of Virginia since 1974 in the Condominium Act in 1989, in the Virginia Property Owners Association Act, the Real Estate Cooperative Act since 1982, and the Real Estate Timeshare Act since 1981. So this has been a law in the books. We're aware of no real abuses. It is an effective tool, and the possibility of foreclosure is a serious consequence. Our community associations recognize that, do not take this remedy lightly, and in fact use it sparingly. There are two theories under which community associations have to recover assessments that are not paid. Assessments are the only funding source for maintenance, repair, replacement of common facilities in a condominium. It is serious stuff, as we know from what happened in Florida now almost 2 years ago. Senator Serval actually has a great study underway to look at ways to increase the ability to reserve. Special assessments are used to fund those. I have a community right now in Tyson's Corner that had a $40,000 per unit a special assessment to deal with pipe replacement. So it is serious, and it's important. Assessments are critical to these associations and their ability to operate. The lien is a 3-year lien. There are two theories under which an owner has an obligation to pay assessments: in rem and in personam. Well, Latin always helps us. In rem is the thing. The lot or the unit has the obligation. In personam, the person has an obligation. So we start first with a lien and that lien creates a net through which clear title cannot pass. And that lien has to be enforced within 3 years. We represent a large community, 2.5 times the size of my hometown in Big Stone Gap in Southwest Virginia, in Northern Virginia, 7,600 homes. Reston is a homeowners association, 10,000 homes. Their assessments are under $1,000 a year. In 3 years, they would have to bring action. They would not be able to use foreclosure as a remedy because the lien only has a 3-year life. The amount is really not always the issue. Some homeowners some owners cannot pay, and associations routinely work with people to help them pay. But there are instances when the association has to go to the mat, and foreclosure is one of them. We do bring, the typical way that this is handled is lien goes on record and then suit is filed in General District Court. And the General District Court creates another lien, a judgment lien, which we cannot enforce till it hits $25,000. The assessment lien can be enforced sooner, that's true. But if you limit the amount to $5,000, Reston, Lake Ridge, Cascades, Brambleton, all large-scale communities which rely on these assessments, and which, by the way, if a non-paying owner means that everybody else has to pay to cover that expenditure. So
Mr. Chairman.
it is not something we use lightly. Sorry.
Senator Stewart, I think, has a question.
I did. I had one quick question for the witness. I apologize for interrupting you. When you said you can't enforce the lien until it gets to be $25,000, does that mean you can't do debtors interrogatories and seek to garnish wages or something like that, or you just can't issue foreclosure proceedings, start foreclosure proceedings?
Thank you, Mr. Chairman. Senator Stewart, the answer is we can, in the routine assessment collection on the personal side, we do debtors interrogatories, we do. The judgment lien is enforced through foreclosure, just like the assessment lien.
Mr. Chairman.
Yes, Senator Stewart.
But you can proceed to try to collect that money through typical collection procedures.
Yes, we do.
It's just that you can't foreclose until the judgment reaches $25,000, which I think is Senator Serval's argument. The whole point of his argument that under those situations it's not until $25,000, but if you don't go that route, you can foreclose if it's $200.
In my experience, been doing this for a while, we've never foreclosed on $400 or $200. It's always a serious delinquency. And even when it's a serious delinquency, it is not always wise to pursue foreclosure because they may not have the funds. Bankruptcy is a possibility, but the possibility of the fact that they could lose their homes is critical to the ability to collect. If people do not understand that they have to be part of the enterprise, a producing member of the community, then other community members have to pick up and carry that load. And it can be a severe consequence for many communities. We have a very active assessment collection practice, not my favorite part of what I do, but it's part of the service that we provide. And no, we do not make a lot of money on it. It is capped, it's limited. It's not a money maker. It is part of helping the community take care of its business and be fiduciaries for the community. Again, we don't take it lightly. We do not take foreclosure as something that should be done. It's very difficult to stand here and suggest that foreclosure should be a remedy, quite honestly. But it is a tool. It's not used routinely, but when it's needed, it's needed.
Thank you. Senator Mason, question for the witness.
Yes, sir. Thank you, Mr. Chairman. Do you have any idea how many have been done in the last year? Or, I mean, it's kind of a random question, but just give us some feel for, you say you don't do it. He says it can be done for small numbers. How many
I have two right now for a condominium in Arlington. One is a $70,000 delinquency. One is a $35,000 delinquency, both over the limit. I can't recommend that they pursue foreclosure. Doesn't make sense. So I say again, it's not always the remedy that's used because it doesn't always make sense. Do I think there are associations who should do a better job? Absolutely. Absolutely. But for those who are trying to mind their business, this bill is devastating. And, you know, lengthening the term of the lien won't work. There's a bill coming your way from the House side that's going to allow title agents to remove liens from record unilaterally. I understand, but that is where, because as a matter of business, there aren't many real estate dirt lawyers around anymore. So covenants and restrictions are not always enforced and not always understood or respected. And these are liens, but I also understand the business reasons for taking them off, so people get clear title. But even lengthening the lien would not solve the problem, in our view.
We've got some more witnesses behind you, I believe, who want to speak on this bill.
Mr. Chairman, Chris Nolan with McGraw-Woods on behalf of the American Resort Development Association Resort Owners Coalition, which is an association of timeshare owners across the U.S., 38 resorts here in Virginia, mainly Williamsburg and Virginia Beach. And I just want to point out that in the timeshare context, first of all, associate my comments with Pia with regard to the mechanics of things, but the timeshare is a different beast. It is not a primary residence. It is a vacation interest, and at that, it's a fractional interest. Sometimes it's 1/52nd of an interest. So it will take an extreme amount of time to reach that $5,000 threshold in order to institute a foreclosure on behalf of the assessment, or on behalf of the association. And Pia is absolutely correct. If that unit is locked up for 4 or 5 years, no one can use it. So then it's not being used, assessments are not being paid, so all the other owners are now picking up the cost of that, and it creates a downward spiral. So would encourage you to not pass the bill. Thank you.
Next. Hi.
Mr. Chairman, members of the committee, Nicole Brenner with Reed Smith on behalf of the Virginia Association of Community Managers. Our members professionally manage the homeowners associations. I won't take any more of your time, but would associate myself with Pia's comments and ask you to oppose the bill.
Okay. Are there any in Zoom who wanted to speak on this bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. Senator Serval, do you have a closing word, or?
Yeah, I just want to say you can take timeshares out by striking 55.1-2211 from the bill, and that resolves the timeshare issue. They're kind of a unique situation given their vacation houses or whatever. Or vacation 1 week interest or whatever. I'm not really sure why that's critical.
What was that reference you made
It
to?
starts on line 518, section 55.1-2211. That code section, I think is the only one. Council might correct me if I'm wrong, but
518.
2211.
Okay. So is there anyone on the committee who wants to offer that as a motion to delete the language contained in 55.1 or the change 2211?
I'll make that motion, Mr. Chairman.
Okay, so I have a motion to remove that section and make it a substitute. And a second? Okay. So all in favor will say aye. Any opposed? Okay, so we've made that change. So did you want to wrap that up, Senator Serval?
Yeah, sure. I would just say, the examples that Ms. Trigiani just gave, the $40,000 assessment, that wouldn't be covered by this. Like the two cases she mentioned isn't covered by this. This has to do with if somebody hasn't paid like $200, $500. I don't even think an HOA should be able to threaten to take your house for that, right? It's your house. And there's court for that. And you can go get a judgment. And like Senator Stewart mentioned, once you get your judgment and your attorney's fees and your interest, which they all get, you can garnish a bank account, you can garnish a paycheck, you can send the sheriff over to snatch their car and sell it at auction. You have all these other things you can do besides take their home. And I don't understand why we're telling people that you can't lose your home for a credit card bill for $5,000, $10,000, $24,999. But if you don't pay $100 at community association assessments, you can lose your house. And some lawyer can charge you $8,000 or $10,000 for legal fees for trying to sell your house over $100. And you can't get your house back until you pay the lawyer $8,000 or $9,000 or $10,000 of legal fees. To me, that's just, it doesn't make sense. So we're dealing with a very small practice, a very small situation. It doesn't happen very often. But I think this bill takes care of the situation, so we don't have to worry about that anymore.
Senator Donovan?
Thank you, Mr. Chairman. Mr. Chairman and Senator Serval, are there practical examples of this? Is this a problem that we're responding to, or is this more of a theoretical, there's an inconsistency in the code and we want to fix it? Because here's the point, is that we often move into business arenas that are functioning in a particular way because those are the tools they have. And we shift the tools and we shift their ability. It doesn't sound like I'm hearing any examples of a problem. And I agree with you on theory, but there's so many unintended consequences. This sounds like a very tangled web that maybe we don't need to act on because there are some downstream complications that we may be disrupting.
Mr. Chairman, let me put it this way. I have one attorney who brought this to my attention. I asked him if he could track down the person who called him, and it had been so long he had misplaced the email he got asking about it. And I'm aware of the association he mentioned, I'm aware of, and I'm sure if I went to land records, I could probably come back here with a series of examples for you. I don't have the time to go down to that county, which is about an hour east of here, and dig through that to find more names of humans to bring here to put before you. But I can assure you that this has happened and happening, or at least, I got calls about it. I don't think it happens very often, and when I heard about it, I thought that's ridiculous, which is why I put this in.
Unless there are other discussion or comment, we're open for motions.
Mr. Chairman, is this something that the housing?
We tried. We didn't get very far, but we looked at it briefly. Didn't have. I don't remember exactly what happened, but we were there and we said let's talk, and then no talk ever happened.
So this was not really looked at in depth in the Housing Commission.
That's fair.
Mr.
So
Chairman,
we could either try that again or take another action. Yeah.
Sorry, Mr. Chairman. I'm just thinking, I mean, frankly, I hear what you're saying, and I'm sympathetic to this, because I don't want somebody's house taken for a small amount, but I'm also concerned by the amount of, other issues brought up. And I almost think it would be better to have the Housing Commission study and demand an answer back before we take a big action on this. Some sort of report or some more information before we proceed.
Okay, so I'm going to take that as a motion to PBI with a letter to the Housing Commission requesting analysis of this as a potential change to Virginia law and other alternatives to see that people have options to get payment without losing their common interest community homes. Okay, so there's a motion and a second to PBI with a letter. Unless there's discussion, we will vote on PBI with a letter. Okay.
Ayes 12, noes 2.
Thank you, Senator.
Great. See you guys soon.
Okay, now Senator McDougal's been waiting. You have a bill before us.
Thank you, Mr. Chairman. Mr. Chairman, I hope I've ironed out the majority of the problems more so than your previous bill. Senate Bill 21. I think it's 1213.
Okay.
I think
This is a D-Port Bill 1213.
Mr. Chairman, I think Ms. Benz has more amendments from me than she would like through this process. So, Mr. Chairman, I can just speak briefly to it, and then if there were a number of things as we went through and talked to different stakeholders that we have would offer forward as amendments to try to bring peace in the valley through all the conversations. Or if you would prefer to take those up first, that's fine.
Why don't you explain the bill while we get the amendments passed out?
Mr. Chairman, this deals with universal license recognition. Right now, and the representatives of DPOR here, but there are about 30 different types of licenses that DPOR regulates. So what happens is if somebody moves into Virginia or wants to work, even if they've been practicing their trade or business in another state, they have to go through a lengthy process in order to be able to be licensed in Virginia. This would set up a process where those licenses could be recognized if that person is in good standing in the other state, doesn't have any pending problems in the other state. So even if they have something that has not been found to be an issue, but they have it pending, that state's qualifications are similar to our states, then they could begin practicing in Virginia pretty much immediately. This has Senator Barker will be happy to know, this has a positive revenue impact because a lot of people will be able to start doing trades in Virginia quickly, and it's something that other states that are competing with Virginia for businesses are doing because they can get talent to come to Virginia that might say, otherwise, I don't want to go through that lengthy process to get my license recognized in Virginia because it would take too long for me to get up to speed to work. Mr. Chairman, the amendments that we have do a couple things. One, they remove the Department of Health professionals to make sure it's not covering anybody in the medical direction. We have a second amendment as we went through and had conversations. Architects and engineers and surveyors are ones that are a different type of specialized. So the amendment that as we went through it, how best to define that would be to remove professional services as defined from the bill, and that's an amendment Ms. Benz will give. And then the one thing that did not make it into the original draft, I believe, was the language that said if you had a complaint pending in your home state where your licensure is, then you would not be available to take care of, to make this automatic transfer until that's completed.
Thank you. Are there those in the room in support of this bill? Or Senator Ruff points out we haven't adopted the substitute yet. I think that is a motion to adopt the substitute, yes. Seconded by Senator Reeves. All in favor of adopting the substitute before us will say aye. Aye. Any opposed? Okay. So substitute is before us.
Mr. Chairman.
Senator Reeves.
Senator McDougal, One of the things I know Senator Bell and I have been working on tremendously is spouses of veterans. And we have thousands of veterans that move in and transfer out each year, trying to keep them here. And some of the issues that the DOD said that we need to work on is the ability for these spouses to get gainful employment when they come. So regardless of who you are, if you're a military spouse and you have those licenses, this would also benefit them, right?
Correct, Mr. Chairman.
Thank you. That's great.
Mr. Chairman, procedurally, we did not come to a agreement on the language around professional services till after the substitute was drafted. So I think the committee would need to take a separate motion on that language because it's not in the substitute. We were working on it. We just didn't get there fast
We can
enough.
do a substitute. We just won't be able to show it online until after committee.
That's fine with me, Mr. Chairman, because enough changes, that might be the better way to do it.
Are there those in the room from regulated occupations that would like to comment on this legislation? Hi.
Hi,
Thanks for being here.
Erin Corman with the Realtors. We do support this bill.
Mr. Chairman, Randy Grumbine representing the Virginia Manufactured and Modular Housing Association. We too support the bill. Thanks.
Mr. Chairman, Andrew Clark with the Home Builders, and we also support the bill. Thank you.
Mr. Chairman, Rob Bohannon representing the Virginia Transportation Construction Alliance, and we also support it.
Mr. Chairman, members of the committee, Robert Melvin with the R Street Institute. We also support the bill.
Which institute is that, sir?
R Street Institute.
Okay. Thank you.
Mr. Chairman, Greg Ackerman with the DC Metro Building Trades. We have no issue with the bill.
Matt Bentgam with the Future of the Beauty Industry Coalition, which is haircuttery, great clips, sport clips. You guys have heard from us for years. This will ensure, vote for this will ensure that you won't have to hear a hair bill for a couple of years. So that should make you feel happy. Yeah.
That's my gift to the committee.
Lou Spencer, Plumbers and Gasfitters Local Union Number 5 in the Virginia Building Trades. We support the bill. We have concerns about licensing in Virginia, but right now my local union is fully employed, 98% fully employed, and I'm bringing in travelers from around the country to work in Virginia, so it would be hypocritical for me to get up here and say that I wasn't going to accept licensing from other areas. Thanks.
Thank you.
Mr. Chairman, this is Joe Horvath from the Opportunity Solutions Project. We strongly support the bill. This bill represents a shift towards moving towards what 20 other states have done in similar legislation.
Great. And what's the Opportunity Solutions Project?
We are a 501c4 nonprofit advocacy organization that we work on public policy that advances reducing barriers to work, which is exactly what this bill does.
Thank you.
Mr. Chairman, good afternoon. Chris Pomeroy representing the Municipal Drinking Water Association and the Municipal Wastewater Association. The licensed operators for our facilities are highly regulated by DPOR, and they're in short supply. We're currently finding ourselves at a competitive disadvantage in recruiting top-tier talent from our neighboring states who've already made similar moves in this direction. So we support this bill and a similar measure by Senator Mason. Thank you so much.
Thank you. I do have a question for council about the substitute. So if I understand it correctly, someone who's licensed in has a similar occupational license or certification in another state for at least 3 years that they've had to pass an examination would be qualified to have a Virginia license. But on line 25, it says they don't have a disqualifying criminal record under state law. Does that mean Virginia law or any state law, or is there any reason it would say state that it just wouldn't say does not have a disqualifying criminal record? Is there a reason we have to say state law, or is that the desire on line 25? Okay, let me ask the patron then. One of the qualifications is that you don't have a disqualifying criminal record, and it says under state law. When you say, I'm not quite sure what you meant by state law, could it be a disqualifying criminal record in another state or federal law?
I'm going to tag a friend.
Mr. Chair, Steve Kirshner. I'm the Deputy Director of Licensing and Regulatory Programs for DPOR.
And that's a reference to an existing statute 54.1-204, which gives DPOR the ability to review criminal convictions along certain specific factors. There's 9 factors that DPOR reviews.
Also, the other question for the patron on line 27, it says no board in another state has imposed discipline on the license. Do you mean to say licensee, or because I'm told you can't really impose discipline on a license, but rather the person who holds the license?
Mr. Chairman, I understand that through the drafting process, there might have been some disagreement on which language. I'm at the committee's will on that one.
Let me ask counsel, do you see any problem on line 27? Should it say licensee? Does that solve anything, or is it not necessary?
Thank you, Mr. Chairman. My comment on that is that throughout the rest of this title, we do say discipline on the licensee, unless there is maybe a different meaning that the patron has.
Okay, if the patron finds it friendly, I would just see if there's a motion. Okay, to change the word license to licensee in regard to imposing discipline on line 27 and anywhere else that it's referred to. All in favor will say aye. Any opposed? Okay, so that's clarified. Yes, Senator Donovan.
I'm wondering if there's an equally amenable language change to your reference earlier on the state. I just feel like there's a lot of different actions that could have been taken. If it's a criminal record, we should probably be reviewing it. I just have a...
Mr. Chairman, I think what the conversation staff and chairman had, if you look at the remainder of that line, it's in accordance with, it references the specific code section. It's state law in accordance with 54.1-204, the Virginia Code. So the reference is not to a generic state law. It refers back to a specific code section that has 9 factors? 9 factors.
Right, but Senator Donovan.
So if there were a federal issue or conviction, would that not be considered because we've said state law?
Mr. Chairman, I think the way that I read that is under that the state law is referencing back to that code section, but
Mr. Chairman.
Yes, Senator Donovan, go ahead.
Just to follow up, I mean, if that language is in the code section to which it references, it can guide the analysis that you do, but I feel like if we box ourselves in with words that we don't really have to have, we may regret it later.
So I guess the question is those 3 words under state law, if those are important for the bill, or if as determined by the board in the Commonwealth in accordance with 54.1-204 would be sufficient.
Mr. Chairman, I think if I'm understanding correctly, the state law is referencing the code section that with the factors. The state law is not referencing state law criminal violations. I think that's the confusion. It's the references to the state law code section, not whether it's a state or federal criminal violation.
I think, Mr. Chairman, that it would then be sufficient that we strike under state law.
Okay, so I hear a motion and a second. Is there a second? A motion to strike the words under state law on line 25. Is there a second to that? Okay, a motion and a second to remove those 3 words. And then all in favor of that will say aye. Aye. Any opposed? Okay, so we have your substitute with that with those 2 changes now before us. Are there any in Zoom, Andrew, who wanted to speak on this bill?
Those in Zoom who wish to speak, please raise your hand electronically.
And we'll go to Senator Ruff first.
Thank you, Mr. Chairman. You referenced that you were taking out the architects, but this preceded that. So do we need to amend this to take that out as a separate amendment?
Mr. Chairman, it depends on how the committee perceived the vote. I thought we were taking up the substitute and the amendment. I think staff is going to have to do a whole, it's going to show up in after this committee as a new substitute in LIS, and it's going to have that section on line 51, inserting a new section E, which will read, not apply to any profession defined as professional services in section 2.2, 4301, which covers architects, engineers, and surveyors.
Okay, I think we need a motion to do that if we're going to do that.
Mr. Chairman, I agree, and I would so move that we do that.
Okay, our motion is second. So all who would like to add that section E will say aye. Any opposed? Okay. So now I think we have this substitute as modified before us. And did you say, Andrew, if there were anyone in Zoom who wanted to speak on this?
There are no speakers, Mr. Chairman.
Okay. Okay, so moved and seconded to report and refer to finance. We'll vote on the electronic system to report and refer to finance, Senate Bill 1213, in the nature of a substitute.
Ayes 14, no 0.
Thank you, Senator
Thank
Reeves.
you, Mr. Chairman, and it's McDougall, but thank you, Mr. Chairman. And
Okay.
I might be older, but I'm better looking than thank you, Mr. Chairman, and the Regulate community. A lot of people came together to try to make this work out, and I appreciate their efforts as well.
Thank you. Reeves. Okay. Are there other senators not on the committee in the room who have, I don't know if D. Steph or Cosgrove or Stanley are here yet. Okay. Who on the committee has, Senator McPike, you've got a bill? Okay, we'll go with McPike and then we'll hear from Sarah Boysko first then. And then you we'll hear, okay.
Thank you, Mr. Chairman and members of the committee. I have SB 1278. This is the rent stabilization bill. And I have a line amendment to exempt residential programs which would be licensed by the Department of Behavioral Health and Developmental Services before we get started.
The amendment is being distributed. Do you want to explain it one more time?
Certainly. So we had some exclusions, and it was an oversight that we left residential programs licensed by Department of Behavioral Health and Developmental Services out of that portion of it on line 44. Other items were assisted living and nursing homes, which were excluded from this. So we just inadvertently left it out.
So the line amendment is before us. If there's a motion to adopt that from Senator Boysko, is there a second? And moved and seconded that we make that exemption. All in favor will say aye.
Aye.
Any opposed will say no. Okay. So that's done, and now we have the bill before us on rent stabilization.
Yes, thank you. I'm carrying this bill on behalf of Loudoun County and Virginia New Majority and other groups that work with our people who are living in poverty. We know that rents have dramatically risen in the Commonwealth over the past several years. The average rents in Virginia increased by more than 10% in 2022 alone, and more than double that, 20% in some localities. These severe increases in rent lead to unnecessary costs and burdens and strains on Virginia families, forcing many families to live in unsafe and overcrowding living conditions, or even worse, facing being unhoused and homeless. And that's certainly something that's happened in my community. Much of this dynamic is attributed to the large financial firms and hedge funds that have purchased residential properties in the Commonwealth and then immediately turn around and increase rental costs for those current tenants. We're not talking about the mom and pop apartment owner or the folks who are really working hard. But, you know, these tenants, many of these people who have lived in their communities for many years can't afford these dramatic rent increases, and they are facing eviction. These investment firms that are capitalizing on this are reaping significant profits, and they're taking them back to other states because they don't live here in Virginia, and our citizens are the ones who are at risk. And if this would be enacted, localities would be able, this is not prescriptive, this is an enabling thing, to limit annual rent increases to an amount equal to the consumer price index in the region. They would exempt new construction of residential units for up to 15 years in order to promote continued housing instruction and increasing housing supply. As I said, they would exempt the mom and pop landlords, with the expectation that it's the larger landlords who have the greater financial and administrative ability to participate in this program. And they would allow a reasonable rate of return for landlords, so that even with this policy in place, landlords would be granted and guaranteed a reasonable return on their housing investment. And they would be able to cover major repairs or other expenses that are unforeseen under this. This would promote tenant housing stability by limiting drastic rent hikes and tenant displacement. And again, the Virginia New Majority, the Virginia Poverty Law Center, and Loudoun County and the town of the city of Alexandria have all expressed strong support, as well as CASA in action. And I have some folks here who are happy to answer questions, but I understand that the housing community, the apartments and the realtors have expressed some concerns, so it may be that we need to look at this in a broader perspective before
we'll hear from them in a moment, but just to be clear, you've exempted people who own less than 4 rental units in Virginia, as well as new construction for 15 years and some other narrow categories.
That is correct. So assisted living and religious facilities, owner-occupied group homes, transient facilities, assisted and nursing homes would also be exempt from this.
And then the ultimate goal of the bill, though, is to limit increases in rental housing for those that are not exempt to how much per year?
It would be adjustable depending on the consumer price index.
No more than the consumer price index.
The percentage.
Well, I'm sure we're going to have questions. Members of the panel, why don't we hear from witnesses first? And maybe we should put a timer on this. I think there's probably going to be a lot of comment. How about we'll take 4 minutes per side in total. So first, those who are in favor of this bill, come forward and identify yourself.
Good afternoon. My name is Mariko Lewis with New Virginia Majority, and we strongly support this bill. As the Senator noted, last year rents increased by over 10%, and for many tenants, their rents have been increasing by much more than 10%, most striking of which one tenant reported that their rent increased by 200% in the Hampton Roads region. And these rent increases force tenants into difficult predicaments, to say the least, and I believe we have a few tenants to speak on that specifically. Again, this is a local option. There's many exemptions which I believe consider housing provider needs, as well as considering what tenants really need right now because of rising rents. And so I urge you to support this and report it out of committee. Thank you.
Thank you. So we have a cumulative timer running, so if people can be as brief as possible, but please identify yourself.
Okay. Hello, my name is Sarandon Elliott, and I'm a staffer for Virginia Senior Power Network. I'm here to urge you to vote yes on SB 1278. Thank you.
Thank you.
Hi, my name is Sophia Vega. I am a community organizer for New Virginia Majority, and I am here with 2 tenants from Southwood Apartments in London Square. They are from Southside Richmond, and I am here to advocate for rent stabilization.
Hola, mi nombre es Shirley Solomán. Vivo en los apartamentos London Square desde hace 2 años.
She is a tenant that I am here to advocate for, and so is she. And thank you.
Thank you. My name is Darcel Pettis, and I'm in the Charlottesville, Virginia, Albemarle area, and I support this because
Yeah, it affects you personally.
You can come back if you'd like to add more. Thank you. Thank you for being here.
Thank you. Sheila Hurley with the Virginia Interfaith Center for Public Policy. We strongly support this bill.
Thank you.
Victoria Horak, attorney with the Legal Aid Justice Center. We represent low-income tenants, and we strongly support this bill.
Thank you.
Hello, Mr. Chair, members of the committee. Christy Marrow with the Virginia Poverty Law Center. As stated, we support the bill, and I just want to emphasize that this is a local option bill. This is a bill that allows communities that are struggling with high rents, like Senator Boyce goes, like some of the communities in Richmond, to do what their community needs. And I understand that the realtors and other groups have concerns about that, but those are concerns that can be raised in their local communities when the individual ordinances are being debated. And so I would urge you to pass this legislation and give those communities an opportunity to have those robust discussions to determine whether they need this sort of ordinance to keep their citizens housed. Thank you.
Thank you.
Mr. Chair, members of the committee, I'm Isabel McLean from Housing Opportunities Made Equal of Virginia, and we support this bill.
Thank you.
And my understanding is that Loudoun County is online if...
Okay, we'll get them in just a moment with the Zoom
Okay.
folks. Are there, well, yeah, why don't we do that? Ask anyone who's on Zoom in support of this legislation who'd like to speak. We can add some time if we need to.
If there's anybody in Zoom who would like to speak in support of this bill, please raise your hand electronically. Mr. Chairman, we do have 2 speakers.
Okay, let's have them.
Jonathan Freeman, please unmute your mic and give your testimony. Ingrid Moran, you will follow.
Good afternoon, Mr. Chair, members of the committee. Jonathan Freeman with Loudoun County. We want to thoroughly thank the patron for bringing this bill forward. Loudoun County is in full support. We are confident that this is a great step in stabilizing the year-over-year rent increases that not only Loudoun is seeing, but the Commonwealth in totality. Thank you.
Thank you.
Hi, everyone. My name is Ingrid Moran from the city of Alexandria, and I'm reading a quick statement from Luz Castillo, a Spanish constituent from the city of Alexandria who lives in the Arlington neighborhood. My name is Luz Castillo. I'm sharing my story. Similar to many families I know, I currently work as a babysitter for my grandchildren and my 2 nephews. We currently live in a 2-bedroom apartment. I'm concerned about the housing situation. As of 2 months ago, my rent was $1,718 a month. When my lease was up for renewal, the landlord said that our rent would be increased by $200. I went to the leasing office to complain because I've been living in this property for 10 years because it's always been a $50 increment. So they decided to only increase my rent up to $85. So now my rent is currently $1,803 plus utilities. It's nearly $2,000. And earning a minimum wage as a household, we are burdened by the high cost of living. Having rent stabilization would be a relief for our family. These yearly increases make me anxious because we feel like we're being pushed out and we do not know where to move next, as there's very few affordable housing in the city of Alexandria. I share my story today with you because we look up to you as elected officials to improve the living conditions for all Virginians, and we'd really like you to focus on the families who are earning the minimum wage, as we need accessible and dignified housing. Thank you for consideration, and thank you for allowing me to express Luz. Thank you.
Thank you for your testimony. Okay, now the opponents who are here in the room who would like to come forward on SB 1278, please come forward. We'll put a timer on for 4 minutes and see if we can get people all in that way. Come forward. Hi.
Hi, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We certainly appreciate the intent of the bill, but it would be devastating for our industry. And unlike other businesses, we don't have the option to offset rental income with any other source of revenue. So when these kind of policies are implemented, we see a big, deferral of capital projects as well as limitation in tenant services, and that leads to serious maintenance challenges for us. So especially in older housing stock where, we need more maintenance. So for that reason, we have serious concerns and ask you to please oppose. Thank you.
Thank you.
Mr. Chairman, Randy Grumbine representing the factory-built housing industry, and we too oppose this bill, and I'll associate my comments with BISMA. Thank you.
Mr. Chairman, members of the committee, Zach Lemaster with Gentry Lock Consulting here on behalf of the Northern Virginia Apartment Association, and we also share the concerns previously stated.
Thank you.
Mr. Chairman, Erin Corman with the Realtors. While we obviously agree there's a housing stock problem and a housing affordability problem in the Commonwealth, we do not agree that this is the way to fix that problem, and we do oppose the bill. Thank you.
Thank you. Thanks, everyone, for being so brief in your remarks. So we have the bill before.
Mr. Chairman.
Oh, is there any others in Zoom who are opposed to the bill? Okay, we're having some IT issues, so we'll continue with members of the committee. Senator Ruff.
Thank you, Mr. Chairman. Senator Bosco, you use the term reasonable rate of return.
Yes, sir.
Do you define that in the bill?
It limits it to the amount of the consumer price index for that region. In the years leading up to the pandemic, the CPI hovered around 2%. As of September 2022, the CPI was up 8% nationally. So it would be flexible depending on what's going on with inflation at the time that the rate was set.
I think Senator Ruff is touching on something, the rate of return, which is what is reasonable and so forth to regulate an industry like this. I'm sympathetic. I have a lot of constituents, including some who spoke about the high cost of housing, and I've got a lot of rental housing in my district, but I'm wondering if you were to limit them to the consumer price index, if you have an apartment complex, particularly a large one that needs some kind of major renovations or wants to upgrade, that you're really kind of handcuffing them. And this is a significant problem, though, and I'm wondering if it's perhaps something that should be studied in the Housing Commission in a little bit more detail and time than we would give it today. Other members of the committee have comments or questions? Yes, Senator.
I do. As much as I respect this patron and I know that her bill is well intended, rent control is probably one of the worst ideas you could introduce into the state of Virginia. And I hope we don't even study it. The fact of the matter is, I heard the young lady speak on Zoom, and she said, I want to improve living conditions. The worst way to improve living conditions is to institute rent controls, because these buildings are going to fall into slums. And I mean, we got to be honest about that. That's what's going to happen. The people aren't going to take care of them anymore. They're going to fall into a state of disrepair, and people are going to be living in horrible living conditions. I have a client who does this sort of thing, and every year he asks me the same thing: is Virginia considering rent control? And I say, no, I haven't heard anything about it this year. Well, I've heard about this year. And he said, and he's a very responsible, good landlord who does this sort of thing, not in Northern Virginia, but elsewhere. But I routinely hear from him, when they do that, then I'm leaving Virginia.
Mr. Chair.
That's what I fear, and then you're left with the ones that worry me about.
Mr. Chair, I just would like to respond to Senator
Okay,
Stewart.
if Senator Stewart's done with his comment, I'll...
Just to clarify, on line 50 in Part E, it specifically says, such ordinance shall provide a procedure by which a landlord may apply for an exemption from the rent stabilization provisions if the net operating income generated by the rental facility has not been maintained due to escalating operating expenses or for other appropriate reasons as established by the locality. So there would be a safety mechanism in order that we do not want to let our properties become slums. That is not my intention. I have constituents who are camping out in front of our Board of Supervisors because they have nowhere to live. This is a major problem in my community. We are really struggling with trying to find an answer. Every time I ask, and I reached out to the industry early on last summer to start these conversations, and the answer was, we understand there's a problem. And I said, what is your solution? And everybody has a longer term solution. We know we need to build more. But for those families that are dealing with being kicked out and having no home, that's not a good enough answer. And so I am here to work with the community. I am here to work with the stakeholders. And I think it's incumbent upon us to find an answer. And I ask that you pass my bill.
So motions would be in order. One opportunity would be to refer this to the Housing Commission. Other opportunity would be to pass it or to PBI it.
Mr. Chairman,
yes.
I would move that with all due respect, because you're one of my favorite senators. Thank you.
So there's a motion and a second to PBI. Are there any substitute motions?
Substitute motion.
Yes.
Mr. Chair, I move that we send this bill to the Housing Commission for additional study and a recommendation to come back before the Senate.
Second.
Okay, so there's a motion, a second, to PBI with a letter to the Housing Commission for review and report to the General Assembly on this topic in general and specifically what we can do. All in favor will vote aye. Those opposed will vote no.
No, I think she would probably like this. Otherwise, it's going to PBI.
Someone misvoted. Could we, let's do this one more time. Again, we're voting on PBI with a letter to the Housing Commission for study.
I don't want her mad at me after
Ayes 9, noes 5.
Thank you, sir.
Okay, thank you for being here. Okay, I'm going to turn this over to our Vice Chair, Senator McPike, while I go across the hall briefly.
Yep. Senator Cosgrove, you're up next.
Thank you, Mr. Chairman. I'm sorry that the chairman's leaving. I had a couple of really easy kills for you here. Mr. Chairman, I have 3 bills before you today. What I'd like to do is to take Senate Bill 1446, and at the committee's pleasure, if it could be rolled into Senator DeSteff's Senate Bill 1082. And I'd like to be a chief co-patron.
All right, there's a motion and a second to roll the bills in and listed as co-chief patron. Is that correct?
Yes, sir.
All right. All in favor? Open the roll. Bill, you got to hush me? No. And the chairman forgot
Ayes
to leave his
13,
proxy,
no
so-
0.
Thank you, Mr. Chairman. The second bill that I have for your action today was Senate Bill 866. This bill was brought to me by the city of Virginia Beach. They are having a very difficult time getting building inspectors and people who could do the inspections. However, there's been a lot of angst on this by a lot of people, so I'm asking this bill to be very gently laid on the table since we can't carry over bills from this session to the next.
There's a motion and a second to PBI. Go ahead and open the rolls. Gently, PBI.
Ayes 13, no 0.
No. No. Okay, thank you, Mr. Chairman. The last bill I have for you is Senate Bill 870. It's Virginia Small Estate Act. This act has been worked on in particular fashion by Ms. Angie Bezick, and if, with your permission, if I could have her detail the bill for you. She's been working with the different stakeholders on the bill.
Yep. Thank you, Senator Cosgrove.
Thank you. Mr. Chairman, members of the committee. Senate Bill 870 provides a more robust structure and protections around a course of action already in code that allows access to fund for funeral expenses. It amends the Small Estate Act to require an affidavit.
Let me interrupt real quick. Do we have a substitute?
Oh.
Yes, sir, we do.
Okay. There's a motion to adopt the substitute in second. All in favor, say aye. Aye.
I apologize.
Motion carries.
It amends the Small Estate Act to require an affidavit to be presented to an asset holder attesting that the funeral home is licensed and performing the actual funeral and its name and address. It attests to the cost of the funeral expenses. Language was added to say less any payments received or expected. In some cases, Social Security pays $225. So if that is coming to the funeral home, then that should be reduced from the amount of their total bill. It's not, we haven't changed the amount. The current code says not to exceed $4,000. A new piece added to from the last version of this bill to attest to the reasons and supporting documentation or supporting evidence that the asset belongs to the decedent. And the last is the successor has provided in writing that it has been at least 30 days since the death and no other person has applied to be appointed as the successor. Additional changes in this substitute. In A, it protects the family by reinstituting the required, the small asset will be at the request of the successor, so you don't have a funeral director just walking in and asking for it. It would be at the request of the person connected to the decedent. In paragraph B1, protects the asset holder. It discharges and releases them after they deliver the asset, and they are provided a receipt. And so that's a full release for them. B2 protects the asset holder in the case of an honest error with regard to a dispute about the asset belonging to the decedent. And C protects the family. The funeral home assumes responsibility in the case of some long-lost relative or somebody coming forward well after that, and then they would be responsible for that. This would allow folks of pretty meager or small means to be able to provide the last act of care for someone they have lost.
Are those others in support of the bill also here to speak?
I don't know, but I did get word from the Bankers Association. They're on board. There is no opposition from any of the other funeral associations.
Okay. Any opposition in the room? Any comments from Zoom?
Mr. Chairman, we do have one speaker.
Okay, go ahead. While we're waiting on that, any questions from the committee to the patron?
There are no speakers, Mr. Chairman.
All right, there's a motion to report. Is there the substitute? Is there a second? There's a motion and a second. Go ahead and open the roll.
Ayes 12, noes 1.
Thank you, Mr. Chairman.
Mr. Chairman, thank you for your time.
Yep, thank you, Senator Cosgrove. All right, Senator Locke, I believe you're up next.
Thank you, Mr. Chairman. I have Senate Bill 839. And Senate Bill 839. JLARC took on the responsibility of conducting a study with regard to reviewing affordable housing in the Commonwealth of Virginia. And at the conclusion of that study, they concluded that Virginia does not effectively identify or plan for statewide affordable housing needs. And in order for us as legislators to understand statewide, regional, and locality-specific, to understand what we need to do for affordable housing, we need statewide, regional, and locality-specific information on housing needs to make informed decisions about how and where to make resources available. And they recommended specific legislative action that would be needed. And so that is the purpose of Senate Bill 839. And what 839 does is it adds to the powers and duties of the Director of the Department of Housing and Community Development the responsibility to conduct a comprehensive statewide housing needs assessment at least every 5 years, to develop a statewide housing plan and update this plan at least every 5 years, to provide annual update to the General Assembly regarding meeting the goals of this plan, and collect and publish certain zoning information collected from Virginia localities. The bill requires localities to respond to inquiries of the department regarding the collection of this zoning information upon request. And that was what JLARC outlined in its information for legislative action. And according to the JLARC report, Virginians who are most affected by the lack of affordable housing are renters, those individuals who have low incomes and most often work in common essential occupations such as home health aides, teaching assistants, bus drivers, social workers. And the Commonwealth has a shortage of at least 200,000 affordable rental homes, and that there is this need for this statewide a need to address affordable housing, and it's so that is why I'm bringing this bill before you today.
And Senator Locke, you have an amendment?
I do.
Is there a motion on the amendment?
I move the amendment.
There's a motion on the amendment. Is there a second?
What is the amendment?
And I can tell you what the amendment is.
I'm going to second it. Adam Evans is going to second. All right, amendments before us.
Did we vote on the amendment? Okay. What the amendment does is on line 117, after plan, we would insert "and the availability of housing that is accessible to people with disabilities."
Questions from the committee? Well, let's do it again. Motion carries. Any questions from the committee? Now, we have, as a committee, we have three similar bills: Senate Bill 1190, Senate Bill from Senator Eben, Senate Bill 1049 from myself, and Senate Bill 839. They have, my understanding is Senator Eben is willing to roll in, but there are some different components in Senate Bill 1049 that are similar, but a little bit more in depth in some sections. Is that right? And so I guess the question would be, are there components that we should distinguish or roll in or adopt and roll into one vehicle versus sending a couple different vehicles over to the House if it carries?
Thank you, Mr. Vice Chair. The difference between your bill 1049. The only difference between your bill 1049 and 1190 and 839 is you have the addition of section 36-55.51, which includes amendments that require certain reports from the HDA. Senator Locke's bill and Senator Evans' bill do not have that section in it.
So Senator Locke, would you be amenable or the committee's discussion to add the additional reporting requirements into Senator Locke's bill and then roll all of these bills into Senator Locke's bill with the co-chief patron list now? All right, there's a motion and a second. All in favor? Aye. Senator Reeves. That's correct. So, we'll do that at the end once we take some testimony. So if those in support, please come forward.
Mr. Chair, members of the committee, Christy Marrow with the Virginia Poverty Law Center, we think this is important work. We think that the information that would be obtained through this study would be really essential to moving the Commonwealth where it needs to be in terms of housing supply, so we happily support the bill.
Mr. Chairman, the committee, Aaron Corman with the Realtors, and we also support this bill.
Mr. Chair, Brian Kozul with the Virginia Housing Alliance, and we support the bill.
Mr. Chair, Isabel McLean with Housing Opportunities Made Equal of Virginia, and we support the bill.
Mr. Chairman, Andrew Clark with the Home Builders Association, we support the bill. Thank you.
Mr. Chairman, Randy Grumbine representing Factory Built Housing, we support the bill as well.
Great, thank you. Any opposition? Any of those waiting in Zoom to speak?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
And so the motion would be to roll. We have to do each individually? All right, so the motion would be to incorporate, first off, let's do Senate Bill 1049 into Senate Bill 839 and list the patron as chief patron. Yeah. All right, there's a motion and a second on incorporation. Go ahead and open the rolls.
Ayes 14, no zero.
And is there a second motion now on incorporating Senate Bill 1190, Senator Evans' bill, into Senate Bill 839 and listing the co-chief patron? There's a motion and a second. All in favor, say aye. All opposed, nay. Right, open the roll.
Ayes 14, no zero.
All right, now we're in a posture for a motion to report, and that's what I'm looking at. Motion would be to report and re-refer to finance. There's a motion and a second. Go ahead and open the rolls.
Ayes 14, no zero.
Okay. I can either do Senator McClellan's bill or I can defer to the great Senator Norman.
You got more bills?
It's actually Senator McClellan's bill, but I can do the other patrons here.
Senator Norman, the courtesy has been provided.
Well, when I get back in charge, I will extend the courtesy to her. So, don't hold your breath, okay? Thank you very much, Senator Locke. I appreciate the courtesy. I've been bouncing between three today. If I could invite the committee's attention to Senate Bill 1094, and I don't believe it's a particularly complicated bill. I've worked in the area of higher education for quite some period of time, and particularly as we went through creating various tiers of higher education institutions and the authority that we would give them. This deals with what's referred to as non-tier 3 universities, and just in case you don't know who they are, it's really sort of the big 5 of University of Virginia, James Madison, George Mason, Virginia Tech, VCU, and
Senator Norman,
William Murray.
I'm going to pause your well-delivered approach, and we've re-referred this to finance. So it's
with the recommendation of positive, right?
Well, there's a lot of green on the board, and it's going to a money committee. So
now I know why Senator Locke was so generous to me. All right, I tell you what, yeah, I may have to rethink this. Thank you very much. I'm glad my eloquence was so persuasive.
Senator DeStefk.
Mr. Chair and members of the committee, I hope to be kind of quick here, and I have 2 little issues with my bill that I need to fix because we've eliminated one portion of the veterans population. So I'm going to request a leave of the committee so I can go by for the day and correct those 2 issues, if that's okay.
Which Senate bill?
This is Senate Bill 1082.
All right, there's a motion to take Senate Bill 1082 by for the day. There's a motion second. All in favor say aye. Aye.
Mr. Chair, members of the committee, thank you very much. I'll have this resolved tomorrow. Appreciate your time.
Other members of the committee to present bills. Senator Stewart.
Thank you, Mr. Chairman, members of the committee. This is Senate Bill 1017. And oddly enough, it's a bill to stop changing the time every year. And you know, nobody asked me to do this. There's no grand anything. It's just that I do not understand why we put ourselves through this every year, 2 times a year. And for a month, you're trying to get your faculty straight and get back on track. And I just thought enough is, I guess because I'm getting older, enough is enough. And so I put in a bill to establish everything as daylight savings time. Truth is, I wasn't even sure what daylight savings time was or not, whether it's the summer or the winter. And I had this interesting little fact sheet when I came in today at my seat. And they don't like my bill because it's daylight savings time, but they like Eastern Standard Time, and they've given you wonderful reasons why we should just stick with Eastern Standard Time. So I'm going to ask that the committee amend my bill to switch to Standard Time and hope I can get a second to that and pass this thing. And then I'll let the doctors discuss the rest.
Wait, Mr. Chair,
You know,
can I ask a question of the patron?
All right. Where are we at here?
Mr. Chair.
What time zone are we in here? What, all right.
I have a question, Mr. Chair.
My confusion.
Senator.
Okay, so Mr. Chair, I love your bill.
Thank
for
you.
people who are outside of light. This really matters. It screws up your entire life. It screws up your schedule. It screws up your sleep schedule. Physicians and researchers will say it's really bad for your health, bad for your circadian rhythm. It's just bad all around. If you've got kids, you can't get them up. Okay, so here's my question for the patron. I also read this. They don't like what you chose.
Right.
What you're choosing, which would be consistent with what they propose, I need someone to explain to me. You're calling it Eastern Standard Time. Is that, what are we choosing?
Mr. Chairman.
Yes.
Mr. Chairman, that would be
Senator
Eastern
Donovan.
Standard Time is when the sun is directly above you at noon. And Standard Time would be what we have in the summertime.
Okay.
In the winter months, they flip us.
When you fall back and you
or
lose.
spring, then you spring forward back to the.
It's when
next
you
Standard
have
Time.
more light.
Right. I think that's right.
So in the summertime, it's light till 9 o'clock. You have more light at night. That means that you would have more light late in the day in the winter instead of having it get dark at 5 o'clock or 4 o'clock.
And so what I'm hoping, and I don't profess to understand all this, I just want to stop changing the damn time twice a year.
Because
it's
you
just
have a lifeline.
It is so ridiculous for all of us. What I would like to do is whatever it is in the summer, just leave it that way.
Yes, that's what I'm for.
and not fall back
Thank
and
you,
jump
Mr. Chair.
forward in the spring and all that. That's what I'm trying to get to. And I'm not sure what you call it. I think they're saying it's Eastern Standard Time.
You have help behind you.
Okay. That's my bill.
Mr. Chair, I think,
Wait a second. All right. So was there an amendment offered in all seriousness?
Mr.
What
Chair,
line?
I would
I just
offer
want to
that
make sure we have it. What line? We have a substitute.
Maybe a substitute.
It'll have to be a substitute.
Okay, so Mr. Chair, I would move the substitute so
There's
that
a
it
motion, a
is,
second. All in favor of the substitute, say
so
aye.
it's standard time.
Aye. Substitute's before us now.
Well,
That's the
my-
quickest substitute I've ever seen produced.
Then that's
This is
my
amazing.
bill, Mr. Chairman. As a
Now this is your bill.
I don't,
All
really,
right,
that's
those,
all I can add.
all right, those in favor? I'm inviting speakers. Those in favor, please approach, identify yourself.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Mike Garahan. I live in Senator McPike's district, and I am affiliated with an organization called Save Standard Time. I brought the handout that caused all this confusion. And
Thank you, by the way. It's
You're
been
welcome.
very helpful.
I thought it might be. Anyway, I hope to bring some clarity to the issue. I was opposed to the bill as introduced, but I would support the substitute that's being considered. As you may have read in the handout, the sleep doctors are unequivocally in favor of year-round standard time, that is, the time we keep in the winter, and opposed to year-round daylight time, which is the time we keep in the summer. As Senator Donovan started to say, standard time puts midday at 12 o'clock. Daylight saving time puts it at 1 o'clock. Now, people enjoy their summer evening recreation, but the morning hours are also important. That first hour of morning sun, in addition to lighting your way to work or school, also dissipates fog, melts ice, and promotes alertness. If an 8 o'clock meeting is difficult with sunrise at 7:20, it would be more difficult with sun rising at 8:20. It's interesting to note in 1974, the U.S. Congress passed a bill to extend daylight time into the winter. They were going to try that for 2 years, but once we tried it, we found we didn't like it, and Congress quickly acted to cut the experiment short, saying, we made a mistake, one winter like that was enough. The health argument boils down to morning daylight helps us wake up, evening darkness helps us go to sleep. And messing with that has negative consequences for our general health.
Thank you.
I'm ready to answer questions if you like.
Any others that here in support? All right.
I believe I had a friend on Zoom to speak in support.
Any speakers on Zoom?
Those in Zoom who would like to speak on this bill, please raise your hand electronically. Mr. Speaker, we have one.
All right, 1 minute.
JP, please unmute your mic and give your testimony.
Hello, committee members, Mr. Chair. Thank you for having me. It's an honor to speak before you. My name is JP, and I am also a member of the 501c4 nonprofit Save Standard Time. I originally came here to oppose this bill because it was supporting permanent daylight time. If it were amended to permanent standard time, our nonprofit would support the bill. We agree that ending clock change is a good idea, but we warn that permanent daylight time is a false clock. And when you extend it into winter, you'd be forcing parents, children, farmers, workers to get up and start their days in the dark for a third of the year, from November into December, January, February, into March. And that's just not healthy. That's not a safe condition. Your sunrise this morning in Richmond was at 7:23 in the morning, which is perfectly reasonable for January. But if you were on permanent daylight time, Richmond sunrise would not have come until 8:23 in the morning today. It gets worse the further west you go. In Abingdon, for example, the sunrise was at 7:40 today. It would be at 8:40 on permanent daylight time. So we do not want permanent daylight time, but permanent standard time we do want. That's the position that is endorsed by the American Medical Association, the National Safety Council, the National PTA, even the Bloomberg Editorial Board, leaders from the Cato Institute, Hudson Institute, the Daily Wire. This is a nonpartisan issue. And as Mr. Garanhan mentioned, we have tried permanent daylight time before, and it actually costs lives. Permanent standard time really is the best way to go.
Okay. Any opposition? Questions from the committee?
Mr. Chairman, I have a question for the
Senator Pillion.
For the sleep medicine.
We amended it to
person.
standard time.
Yeah.
I think I understand what's, look, they're a lot smarter than I am, so I'm fine with that. I just want to stop changing the time.
Question here. Yeah.
Just want to stop changing the time.
Mr. Chairman.
All right, Senator Pillion.
So I have a question, yes, for you. So the U.S. Senate passed legislation that goes into effect if the House passes this in 2023. What did they pass?
The bill,
Did they pass what you want or what Stewart originally proposed?
The bill the Senate passed last March was for year-round daylight time,
Yes,
and we
that's what
opposed
we
that.
Okay, so, okay. Yeah, did everybody get that? So, so, Mr. Chairman, what the
Senator
U.S.
Pillion.
Senate passed was what Senator Stewart originally proposed. Is that correct?
Yes.
Okay. Yes. Thank you.
Mr. Chair.
Senator Vogel.
Mr. Chair, if I may add something?
The floor is Senator Vogel's right now.
Okay.
You
Go
wanna
ahead. Let
and
him go.
defer?
Mhm.
Go ahead.
I defer to you. Go ahead.
The patron, Senator Stewart, reminded me that current U.S. law allows Virginia to observe standard time year-round without Congress acting. Arizona and Hawaii already exercise that option.
You need congressional authority to go to daylight savings time, right?
That's correct.
I'm looking at staff here.
Senator Vogel.
Are y'all thoroughly confused yet?
Okay.
So,
Mr. Chair.
So we have the choice before us is, the substitute before us is a choice for winter, and the original bill is a choice for summer.
Right. Mr. Chair, I erred. Mr. Chair and Senator Stewart, I erred. I like summer. I like summer all year round. I made a mistake. I would prefer that we not change the time. I agree with both the patron and the advocates that the time change is super disruptive, and it causes, for sure, I mean, you read the data about the increased number of heart attacks, the increased number of people falling asleep at the wheel. I mean, all that's really obvious. Where you and I would disagree, Mr. Chair, would be over which you choose. Your view is you would prefer to have less darkness in the morning. I prefer later in the day, at the end of the school day. There's so much value in having that extra daylight later in the day. I prefer what the U.S. Senate has passed, which is what Senator Stewart initially brought. I was hastily Googling this and reading what you said and thought that that's what we were doing and that's what you were advocating and that he was dumb. But now I realize I'm dumb. I'm way dumber than Senator Stewart, and I apologize. So I would just like to say to the committee that my preference would be, and I withdraw my earlier comments and apologize profusely, that my preference would be for the bill in its original form. So thank you, Mr. Chair and members of the committee. I'm not certain, Mr. Chair, did we vote on the
So
substitute?
we need a motion to reconsider the vote, which we adopted, the substitute.
I would love to make that motion.
Is a motion a second? All in favor?
Mr. Chairman, let me clarify. Senator Stewart will have to change his clock again next spring.
I don't care what time we observe, as long as we don't have to change the time anymore. So I'm at the will of the committee, whatever y'all want to do. Oh, my goodness.
All right, there's a motion to reconsider the adoption of the substitute. All in favor say aye. 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 All opposed? We got one no. All right. We now have the original bill, Senator Stewart, and I believe you've gone from 2 in support to 2 in opposition now, as the bill stands before you.
I'd listen. I live by the will of this committee. I just don't want to have to change the time anymore. Whatever
Mr.
y'all
Chair,
want to do.
move to report
There's a motion and a second to report.
as unamended. As an
The
unamended.
original bill as presented. Open the roll.
Ayes 10, noes 4.
Can anybody check on the whereabouts of Senator Eben? Because I'd really like him to be back here now. All right, Senator Stanley. All right, Senate Bill 1114.
Senate Bill, Mr. Chairman, members of the committee, Senate Bill 1114 is actually to never acknowledge daylight in Virginia ever again. Okay, that's not the bill. Senate Bill 1114 is actually a concept that comes from the home builders, and certainly what we've been trying to address in the south side of Southwest Virginia and our rural areas is that we have a lot of green space, a lot of potential development, residential development. We don't have perhaps the developers that perhaps Northern Virginia has and some of the other regions. But sometimes those developers up in Northern Virginia don't have enough to do but might want more to do. And we have a housing shortage, and certainly with some of the industries that are coming in right now. But we have those green spaces. So what this bill essentially tries to do is create a tool at the Department of Housing and Community Development, which allows then the department to assist localities to promote greenfield sites or even existing buildings that could be rehabilitated, turned into multi-use or multi-family dwellings, residential, mixed-use development. So it's kind of like taking, a long time ago, we did a bill, and I remember what we would do to advertise our industrial sites being shovel-ready, to advertise them to businesses so that they could go onto a portal and a website and determine for themselves, hey, we may have an opportunity here in the Commonwealth of Virginia to put our business and also to construct whatever industrial buildings are needed to perform that business. This basically empowers the director of DHCD to add that the department shall develop and maintain a Virginia residential sites and structures locator portal. And that way, what we're trying to do is marry up those developers with those regions that are actively trying to develop properties and advertise those properties. And especially, not only will that address the housing crisis that we have, housing shortages that we have in those areas, but also invigorate the economy. When you have those kind of developments going on, industries do note those, because sometimes when the industries come to Southside or Southwest Virginia, they look at our schools, they look at our healthcare system, and they look at our availability of housing. And those decisions sometimes are made, if there's a lack of housing, where they go in another direction and to another state. And also there's the ability to have a local option. Localities are the ones that are going to determine which properties or sites are submitted into the sites and structure locator. And the only requirement is that the site or structure has to be under public ownership, public and private ownership, or private ownership if the permission is given by the owner. And that way, no sites, no developable sites will be put on there without the permission or knowledge of the owner of that site. And that's the bill, Mr. Chairman.
Thank you. Any questions from the committee?
Excuse me.
Those in support, please approach and identify yourself.
Stewart still here? Maybe Richard can come.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia, and we support the bill. Thank you.
That was really
Mr. Vice Chair, Randy Grumbine representing Factory Built Housing. We think this is one of the best ideas we've heard in a while as far as stimulating new greenfield development, and gives the localities the controls to do that, and so we fully support this bill.
Mr. Chair, Brian Koza of Virginia Housing Alliance. We support the bill.
Aaron Corman with the Realtors. We also support the bill.
Lou Spencer, UA Local 5 Plumbers and Gas Fitters, Virginia Building Trades. We support the bill.
All right, those in opposition? Questions from the committee? There's a motion and a second to report.
Ayes 14, no 0.
Congratulations, Senator Stanley.
Thank you, Mr. Chairman. I appreciate it. I'll tell the other chairman to come back over as soon as possible for you. Thank you, sir.
Senator Hashmi, I'm sorry. Senator Stanley, we need to send that one to Finance, just as an FYI. So we need to strike the roll and renew a motion of report and re-refer to Finance.
That's you. That's old man.
Almost got there.
Ayes 14, no 0.
Congratulations, Senator Stanley.
That kind of, yeah. Never mingle. Never.
Senator Hashmi.
Thank you, Mr. Chair, and members of the committee. There is an amendment to this particular bill. It's SB 941.
All right, Senate Bill 941, and we have an amendment.
And actually, before you take a vote on the amendment, there was a part of the amendment that wasn't included in the written draft that you've received, and that portion simply takes out all changes that were made to the code, leaving these particular changes intact. So the changes to the code would have been referencing the timeline for the amount of the security deposit. So, for instance, in line 40, where it says equal to 2 months, the bill that's in front of you struck that out and said 1 month rent. We're going back to the original language. So anything that was struck out from the code goes back to the original language, and only the amendment that is in front of you then will be making the changes in a line, starting with line 177. So I hope that's not too confusing.
It is. And so I'm going to call a friend here with counsel because I didn't follow. All right, so we're going to have a substitute developed with all those amendments. And she does substitutes fast when time's involved in sunlight. All right, it's a motion on the substitute.
So
There's a motion and a second. All in favor say aye.
Aye.
Aye. Motion carries. Substitutes before us.
Thank you, Mr. Chair. And the reason for the substitute and these changes is we were trying to work with many different parties and try to reach an agreement. So the original goal of the bill was to take away the disproportionate pressure on so many of our folks that are seeking to rent property and face that prohibitive cost of security deposits that are out of reach. But in order to reach an agreement with many of our stakeholders, we are seeking now to simply make the change that begins on line 177, that tenants actually be able to be present when a final inspection occurs. And so the change is only that a final inspection shall occur on or immediately after or on or within 5 business days after the tenant vacates the dwelling unit. And this is to expedite the process for tenants to be able to have their vacated building reviewed so that their security deposit can then be returned to them in a more expeditious manner. If there's no damage to the building or the dwelling unit, if there's no serious issues that need to be addressed, that the landlord and the tenant can complete that process of returning their security deposit in an efficient manner, and certainly one that will help the tenant in the process. We know that many tenants are vacating their units, moving into sometimes another rental property. They need that cash in a quicker manner in order to make the next set of security deposits, the next month's rent, and so forth. So this simply alleviates the kind of financial burden that simply that does impact so many people in the rental market.
Okay. Any questions from the committee before we go to public comment? All right, those in favor and support? Senate Bill 941. I'm going to take opposition then. Or, I'm sorry, Christy, do you want a sidebar while we take other testimony?
I'm sorry, Mr.
We have
Chairman.
a very long docket still and another subcommittee after this.
Yeah, I'm sorry, Mr. Chairman. I was just getting a bit of clarification from the patron. We do support this bill. We thank the patron for bringing this, and we, of course, thank all the stakeholders for working with us on this. And the reason that we support this bill is because it does provide for a shorter timeline for landlords to return that security deposit to those good tenants who have not caused any damage to the property, who are present at the final move-out inspection, and who provide the landlord with a forwarding address or an email to email any kind of information on how to get a direct deposit. And so we think this is an excellent step forward.
Thank you. Next speaker.
My name is Victoria Horak. I'm an attorney with the Legal Aid Justice Center. I represent low-income clients, and this would be very useful for them in trying to expedite their security deposit return because, as the Senator mentioned, they need that money immediately to be able to move, and it's often a barrier to finding new housing for them. Thank you.
Thank you. Any in opposition?
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We have serious concerns about limiting security deposits. It's usually unpredictable on how the unit is going to be left after a lease term, especially if it's above the normal wear and tear. So that's our concern. And then we're okay with, a tenant coming in and being there during an inspection. But that timeline of 5 days is usually not up to the housing provider. And so for that reason, we ask that you oppose the bill. Thank you.
Mr. Chairman, Aaron Corman with the Realtors. We also have some issues with the bill, and although we do appreciate everyone's attempts to try and come to peace in the valley, we were not able to do that. It does not say 5 business days; it says 5 days, which we find to be a little concerning. It's not clear whether you have to receive it within 5 days or it has to be sent within 5 days, and there's some concern over with my members over the move-out inspection and whether now the tenant will control when that is versus if the landlord will control it. And finally, sometimes a contractor or someone on staff, a handyman, is the person that goes through and does those inspections, but sometimes they have to come later and look through the unit, and it's possible that something could have been missed. So we do have some concerns about this and currently oppose the bill as it stands. Thank you.
Mr. Chairman, question for the last.
Senator Bill.
I guess one of the issues I think about is we have inspections at the end. What about inspections at the beginning that would compare the two? Would this impact that, or would you have to have a tighter inspection change at the beginning of it to document some way that the property was received in a certain condition and exited in that same condition?
Most of our members do move-in inspections now. I would think they're always comparing those two items. the move-in and the move-out inspection. The question is if the tenant gets to decide the move-out inspection, but it's not the same day that the handyman or the contractor can get there, maybe that person needs to come after, and we'll find things that the landlord or the property manager isn't necessarily have the background to see. We want to get them their money back as soon as possible, but this really restricts us and is actually unclear. I think it's probably going to cause problems in the courts with who's obligated to do what when. Did that answer your question?
Mr. Chairman?
Senator Bell.
I guess my follow-on is more of, be more specific. Do you have to tighten up the pre-inspection to make the post-inspection work? Because I think a post-inspection, that is going to be reliant upon the agreed-upon conditions at the pre. So my question is that going to have to change for this to work?
It's possible. I would have to look at the exact language in the code, but it is possible. It definitely would probably have to change in practice. I'm not sure if it would have to change in the code as well, but I see what you're saying, yes. The move-in inspection will probably have to be altered in some way.
Mr. Chairman, one final question. The 5 days, is that 5 business days something you would find acceptable versus 5 days, or is that a no-go? Because I would agree 5 days might be short, particularly if it's a holiday period. 5 business days seems more reasonable.
Well, I definitely can't speak for all the stakeholders. I know we've had this conversation on another bill that is out there. I know we felt more comfortable with a 7 business day turnaround, but there is language in this bill. It would have to be, it would have to specify whether it's the money is sent by that time. If you're putting something in the mail and then you're sitting and waiting, I don't want the landlords to be held liable if it never gets there. So would it be, has it sent or is it received by that time? It would need, the language need to be tightened up some. So.
Mr. Chairman.
Senator Mason.
So I think everybody like to get them the money as quickly as possible. But you said they need the money sometimes to move to another place. If you do 5 days, they've got to move to somewhere when they evacuate the premises. So they're not going to get the money in time to put it down on the next place, even in 5 days, right?
Mr. Chair and Senator Mason, I would argue that having the funds restored to the tenant who's vacating can help that tenant address other needs that they may have, whether it's moving expenses, food. The savings that they have will be inevitably going towards the security deposit and all of the other ancillary expenses of moving into a new unit. That might lead them with very little financial resources to address other concerns that they have, whether it's starting their utility services, buying food for their family. So money is always going to be useful, and the sooner it comes, the better.
Absolutely. Mr. Chairman? All right, so we're at 45, and you're going to 5. There's a lot of room in between there. I don't read the questionable part about, who sets the timing and the date, but you may be right. Can we find some ground here? I mean, 45 is a long time. 5's a short time.
Mr. Chair and Senator Mason, if I may address, I think we heard a willingness to go to 7 business days, and that within that 7 business days, the funds be dispersed. Not that they be received, but that they be dispersed, and I would take that as a friendly amendment and certainly accept that.
Okay, let's take some comment to that suggestion.
I just want to clarify. So when we were talking about the 7 business days on a different bill, that was in an emergency uninhabitable unit situation upon move-in. So that person really had no other place to go. So again, I can't, without going back to my members, commit to 7 days, nor can I speak for other stakeholders. But I would be happy to continue working on this bill with the stakeholders and the senator if you would want more time.
Mr. Chairman.
Senator Bell.
I request with the patron's permission we go by for the day, and there's one other issue I was going to bring up is
well, let's take up the motion. There's a motion, and I heard a second to take by for the day. Speak to the motion.
Question is, I think a question for council is, if we change this from the 2 months to 1 month's periodic, is there a clause in this would not grandfather it, or would people who've taken 2 months have to refund? Because I was looking for a clause and I didn't see anything on that.
Well, if we are going to be preparing a substitute, as we were discussing earlier, you'd be restoring the original language of the law, so it would still be 2 months, not 1 month.
Okay, I would just recommend if we take this by, we make sure we address that so we don't cause a problem when there.
All right, there's a motion to take by for the day. All in favor, say aye. Aye. All opposed. See you next week.
Thank you, Mr. Chair.
Senator Reeves, you're up next.
We could have, but the way I'm reading this, if you've taken 2 months, you got to give them a month back.
Thank you, Mr. Chairman. I have Senate Bill 1208, and Mr. Chairman, I know I briefly spoke to you about maybe an amendment, and I think I have some verbiage to the bill. But what this would do, what I was trying to do was...
I'm sorry, this one was re-referred?
Where'd it go?
This is Commerce and Labor, sir.
All right, Mr. Chairman.
Congratulations.
Are we doing sub now?
I got 3 or 4 bills. Anybody else? Yeah, I think so. Oh, you want to do McClellan?
I can do the McClellan.
All right. All right. Senator Locke is going to be doing Senator McClellan's 1384. Is that right? Okay, it's 1330.
Okay, this is Senate Bill 1330. Which is Senate Bill 1330 increases from 5 days to 14 days the mandatory waiting period after a landlord serves written notice on a tenant, notifying the tenant of his non-payment of rent and of the landlord's intention to terminate the rental agreement if rent is not paid before the landlord may pursue remedies for termination of the rental agreement. And the purpose of this is to deal with what very clearly is an eviction problem in the Commonwealth of Virginia. And giving tenants more time to pay rent will help keep them out of debt. 14 days give tenants more time to get another paycheck, borrow money from family, or access rental assistance available in their community. Eviction laws drag tenants into debt. Once the landlord files a lawsuit, the amount of money tenants must pay to the landlord's attorney's fees are added. It is more financially beneficial to avoid an eviction lawsuit in the first place. If a tenant isn't able to pay all he owes and a case is filed against him, he will owe the same amount in late fees, which are capped at 10% of the amount owed, and court costs whether the case is filed on the 6th day or on the 15th day. Giving tenants more time to pay rent before the eviction is more beneficial. Limiting options for tenants to catch up on rent is short-sighted and cruel. In a state that has the highest eviction rates in the nation, we should offer as many ways for tenants to avoid being evicted as we can possibly think of. So that's the purpose of this legislation.
Thank you, Senator Locke. Those in support?
Thank you, Mr. Chairman, members of the committee. Christy Marrow with the Virginia Poverty Law Center. We thank Senator Locke and Senator McClellan for bringing this legislation. You will recall that during the COVID era, we did have a temporary 14-day time period for the pay or quit rules, but it also had a payment plan piece to it. I want to clarify that this is not going back to that law. This is just extending the 5-day pay or quit period to 14 days, which benefits both tenants and the court system. If you look back at 2017 and 2018 data for eviction judgments, 45% approximately of the eviction judgments for both of those years were for less than the median 1 month's rent across the state. And what that tells us, I think, is that if we give tenants a greater opportunity to pay the rent after they get that pay or quit notice, it's only 1 month's rent that they're being sued for. It's likely that they can come up with that. In 5 days after you get a pay or quit notice, most people are not getting another paycheck. In 14 days, that's gotten you to the 15th of the month. Most people have another paycheck. And often what's happening in these situations is that some single crisis
You have
has
a long
occurred.
line behind you? I think we hear you.
Okay, thank you. We
Thank you.
support the legislation.
Appreciate it.
Members of the committee, my name is Victoria Horak. I represent tenants across Central Virginia, as I've said, who are low income, and this bill would be crucial for them in eviction cases. Many people, as Christy Mara said, do not get paid within the 5-day pay or quit period. They will get paid usually within a 2-week period. It's also a crucial period of time for people to get local rental assistance funds. It's very hard for any nonprofit organization to get money in the hands of a landlord within 5 days. And this would allow people to avoid the additional court costs that they get once their cases are in court, once they are sued by their landlords. So we support the bill.
Thank you. Next speaker.
Yes, my name is Darcel Pedersen. I support this bill because if you give us 7 more days, it would probably prevent us from being homeless because we could have gotten our rent checks and been able to do it, or being able to have found a family member that could have loaned it to us to help us instead of causing not just us more lawyer fees, but all them people that oppose.
Thank you.
Good afternoon. We'd like to thank the patron for bringing the bill, Sheila Herlihy, with the Virginia Interfaith Center for Public Policy, and we support the bill for all the reasons outlined. Thank you.
Thank you.
Mr. Chairman, Isabel McLean with Housing Opportunities Made Equal Virginia. We support this bill because we believe it will reduce avoidable and unnecessary evictions. Several of Home's housing stability clients tell us that they would have been able to pay the rent themselves if they'd been given enough time for another paycheck to arrive. So we ask that you support the bill.
Thank you.
Mr. Chair, Brian Kosu with the Virginia Housing Alliance. Our members represent everybody from tax credit investors all the way to homeless shelters. And looking at this as a continuum issue, there have got to be some pressure relief valves inserted into the continuum to keep people out of homelessness. So right now, shelters are overrun. There's no housing to put people into. And there's just too much pressure in the system. We think this is a potential solution to that. So we support the bill. Thank you.
Great. Thank you. Those in opposition?
Mr. Chairman.
Senator Reeves.
I just had a question. Is there any data that says how much time, maybe Christy or anybody out there that has any data that says how many evictions could have been prevented if they would have gotten those extra days?
Yeah.
Mr. Chairman, Senator Reeves, we don't have that specific data. We do know that there were approximately 30,000 eviction judgments entered those 2 years I mentioned, 2018 and 2019, for 1 month's rent or less. And I think that we can infer from that a fair number, probably thousands of evictions those years, could have been prevented if people had the chance to get one more paycheck.
Thank you.
Thank you.
Thank you. All right, those in opposition, and then we'll have the new Senator McClellan come up and finish out. How about that?
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We have serious concerns about the timeline of this bill. Already after a 5-day industry grace period of 5 days, we have a 5-day pay or quit notice, and then an unlawful detainer is filed. And then after that, it usually takes 45 to 60 days to get a court date set. And in 2020, we tried to address this situation by amending the Virginia statute on rights of redemption, basically saying 48 hours prior to a scheduled eviction, you can wipe the slate clean, and then in separate legislation to say that unlawful detainers that don't result in an eviction will not count toward a tenant's record. And then we do see when you do extend that timeline, there's more debt that's accrued when that eviction is executed. So, and that's going to follow them in future housing searches. So for that reason, we strongly oppose the bill. Thank you.
Mr. Chairman, members of the committee, Zach Lemaster, Gentry Law Consulting. On behalf of the Northern Virginia Apartment Association, we share the same concerns. Thank you.
Welcome back, Mr. Chairman. Randy Grumbine representing Factory Built Housing. We too oppose the bill because of the length of time it's in the courts to allow the tenants to catch up and be right before their court date. Thank you.
Senator McCollum, did you want to close out?
Yes. I'm sure Senator Locke did a great job presenting the points, and so I'll just respond to a couple of the last ones. I will remind the committee that in response to the COVID-19 pandemic, we passed legislation in 2020 to temporarily extend the pay or quit period to 14 days and require the larger landlords to offer a payment plan. That provision has now expired. The sky didn't fall. And since the pandemic protections expired, evictions have risen back to pre-pandemic levels. There have been over 10,000 evictions filed across Virginia last month alone in December. And this bill is just intended, as we did during the COVID pandemic, to give tenants another pay period in order to try to avoid eviction. And again, the sky did not fall when this was the law temporarily.
Mr. Chairman.
I hear Senator Donovan.
If I wanted to ask Bisma a quick question for clarification that you may want to respond to. So I want to understand the timeline as you expressed it. At 5 days, you seek the court's intervention, but you don't get into the courts for 60 days.
Yes.
And is the renter in the unit for all that time until there's a court decision?
Yes.
Do you have an average of so they really are getting 14 days?
Yeah, they'll have that whole timeline. And during the pandemic, when this was implemented, we saw serious court delays, and that was extending the timeline even further. And so we felt that unlimited right of redemption provision, that 48 hours before, if you pay in full, it's not going to be under record, that addressed the situation that we had on hand.
So the 48 hours before the court date, you can pay in full?
48 hours before an executed eviction. So even more time.
Okay. And thank you, Mr. Chairman. I apologize. Are they accumulating fees that whole time?
Yes.
Okay. I think that's maybe at the crux of the problem.
Yeah.
Because it's hard to claw out from there. But thank you, Mr. Chairman. That helps me understand the timeline a little better.
Okay. Were there other?
Yeah, I would like to have Christy respond to that with a couple of points.
Okay, Ms. Mora.
Thank you, Mr. Chairman. Senator Donovan, first of all, on the timeline, I think it varies widely across the state. We know from our legal aid attorneys in Central Virginia, people are getting into court and getting hearings and final judgments within 3 weeks of filing. So it may be very different in Northern Virginia. I think it's even shorter in some other places. But in Central Virginia, it's about a 3-week timeline. And I think one thing that's really important, I appreciate that BISMA and others in the industry have worked with us on the right to redemption, which is, of course, when you can pay 48 hours before the sheriff comes. That stops the physical eviction. That eviction judgment is always on your record. There's nothing under our law that allows that to be expunged, even if you pay even if you pay in court. Even if you walk out after the judge issues the order and hand the landlord the money, you're not going to get physically evicted, but you're going to have a hard time finding housing in the future. And this is what we're trying to avoid, all the ramifications.
Yes, Senator Donovan.
So, in principle, I'm with you. I just don't know that this is the solution. It seems that the accumulation of fees, it seems like we already have individuals that have 3 weeks 5 days before you can seek a day in court, 3 weeks that they're waiting, you're saying on the shorter end. So if they presented the full rent in any point in that timeline, it would be more than the 2 weeks you're asking for. But the only difference is that fees start accumulating at 5 days?
No, and thank you, Mr. Chairman. Senator Donovan, that is not the way that it works. How it works is once you are late, the landlord can charge up to 10% of the principal amount as a late fee. He can do that on day 6. He can do that on day 26. It's still only 10%. So it doesn't go up as you wait. The other fees don't begin to accumulate until the court case is filed. And then you have your court costs and your attorney's fees. And the attorney's fees can continue to accumulate as that case moves forward. What this bill attempts to do is to stop that case from ever being filed. And so you're not accumulating more fees if you can pay the full amount that's owed, including the 10% late fee, before that 15th day. That's what this bill is striving to do, and I think it will be successful if you move it all the way to the finish line. I think we will see a real decline in evictions because people will get that extra paycheck, or if they're not able to work at that time, they have time to go to their local eviction reduction program, and there are some in the state that are very vibrant, and then they have those extra days for them to process the checks. And so there are no extra fees that are accumulated. If you pay, then you avoid fees. If you don't pay before the case is filed, then the extra fees accumulate. So this helps you pay before the case is filed and you accumulate the fees.
Thank you. Yes, Senator Mason.
Ask Ms. Morrow a question. So this is maybe one of the first of many pandemic changes we made that now we're seeking to make permanent. You used examples from pre-pandemic, which makes a lot of sense. Were there efforts to make this change pre-pandemic?
Yes, yes, there were. They did not succeed, obviously, but yes, this has long been a contention of the tenant advocates across Virginia that having, and it's for this very logical reason, and the reason that we normally appreciate an effort to compromise with the landlord groups. But here, it's just this logic that says if you have 14 days instead of 5 days, instead of 10 days, 14 days, you're going to get another paycheck. And that's what people need to be able to pay the rent.
Thank you. Okay, are there,
Move to report.
there's a motion and a second to report SB 1330. All in favor of reporting will vote aye. Opposed, vote otherwise.
Vote for me.
Ayes 9, noes 4, 1 abstention.
Okay, thank you. And was that your last bill, Senator?
I have 2, unless you took them already.
Okay.
All right,
What's your next bill?
The first one is Senate Bill 1384. And basically what this bill does, it deals with restrictions on pet owners, and basically says that a housing redevelopment authority, so a public housing authority, could not add additional burdens on pet owners beyond those that locality provides in their zoning ordinances. And what the problem we're trying to get at is that we have seen a number of pet owners who cannot find affordable housing options, particularly in our public housing, because they have certain types of pets. And this bill is just saying whatever the restrictions are that are in the zoning ordinances, those will apply to the redevelopment authority units as well.
Okay. Are there witnesses in the room who'd like to speak in favor of this legislation?
Thank you, Mr. Chairman, members of the committee. I'm Holly Hazard with the Virginia Federation of Humane Societies. This bill will make a huge difference for both people and animals. Renters with pets are often already limited by arbitrary restrictions like breed and weight restrictions, pet limits, and a family without much financial flexibility will have even fewer choices about where they live. It's not hard to see how so many families with limited options are forced to choose between a home and a beloved family pet. Our members have dealt with situations where people have been devastated by relinquishing their animal due to a housing or landlord situation. For example, one shelter in Northwest Virginia reported that in 2022, 46% of relinquishments to their shelters were due to housing issues. Another shelter in Southwest Virginia was experiencing over 100 calls a month last year with individuals struggling to maintain their pets, and housing was one of the primary reasons for relinquishment. They noted that if housing did allow pets, they had to be small and could not be any bully breeds or mixes. We know that using perceived breed or any single factor approach to improving community safety is ineffective and discriminatory. There's no evidence that can indicate that a dog's behavior is based on their physical characteristics. Nothing in this bill prevents a housing authority from implementing broadly applicable pet policies such as prohibition against causing a nuisance or a threat, and implementing a noise policy, which are far more effective in keeping the community, property, and animals safe. Nothing prevents them from assessing and charging a resident for damages. Please support SB 1384 and let all Virginians decide, regardless of income, what their family should look like.
Thank you. Hi.
Hi, Mr. Chairman, members of the committee. My name is Tabitha Treelor. I'm the Director of Communications for the Richmond SPCA, and we do support this bill, and we thank Senator McClellan for filing it. Virginia law in Section 3.2-6541 already expressly prohibits localities from banning ownership by particular breed. The state already recognizes that breed-specific legislation does not create a safer community, yet our public housing authorities in many areas enact breed restrictions either explicitly or by putting severe limits on weight. More than half of dogs in American homes are of mixed or unknown breed, so these policies are relying on physical appearances in most cases to make life-altering decisions about a tenant's family member. These arbitrary policies are all too common and present the greatest challenge to those who have limited choices about where they live and how much they can spend on rent. And therefore, on behalf of the Richmond SPCA, we ask that the committee supports this bill.
Thank you. Are there those in the room who oppose this legislation?
Sort of opposed. Mr. Chairman, members of the committee, I'm Tyler Craddock. I represent the Virginia Association of Housing and Community Development Officials. We're public redevelopment housing authorities. Obviously, as it's written, we're not at a yes yet. We've expressed some concerns and discussed those with your staff. We've been very receptive to those. We're obviously willing to, as we go forward, to work with Senator McClellan and her team, but we're not at a yes. And our concerns, if you look at the way the bill is, if you look at the way the bill is structured, some of the things that any dutiful landlord may have as part of their pet policies can't do. So some landlords choose to charge some form of pet rent or pet deposit, which helps recover those costs, the wear and tear that animals can in doing it. And I say, I'm a dog person, right? And I loved my beagle Freckles, but yeah, I'll admit she could do it. She did a number on my office. But so we know we have to recover those. If you read this bill, there's no limit on a size restriction. We know that's been a concern of some of the advocates, but no limit whatsoever. No limit on the number, right? And so this, for us, that's just way too far and broad. And so we're not at where we're in a position to be able to support it at this time.
Thank you.
Thank you.
Are there any on Zoom who would like to speak on this bill, for or against?
Those in Zoom who would like to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. Are there members of the panel who have questions for Senator McClellan?
Well, can I just make a comment?
Please.
I am open to amendments. I think we did not have suggested language presented, and so we were going to work on some language. If you'd like to take this by for the day for us to work on that language, I'm happy to do that. Yeah.
Okay. So.
Yeah.
Okay, so I think there's a motion and a second to take this by for the week. So without objection, we'll take it by for the week, and you can bring in a substitute or talk to the advocates on the other side. And you had one more bill, did you, Senator?
Yeah, one more. This one, so you may remember that in 2021 in the budget, we created the Community Development Financial Institutions Fund that would serve as a repository for current and future stimulus funding streams, general fund revenues, and any other sources of funding that would be a resource for Virginia's community investment in housing and economic development and community development. What this bill does is to codify that fund. That's basically the bill.
Okay, did you bring any witnesses today, or are there,
Yes.
okay, for those who want to speak in favor of the bill, if you could briefly tell us your support and who you are, and why you're supporting the bill?
Thank you. Thank you for having us today. My name is Leah Freeman. I'm CEO and president of Bridging Virginia, a community development loan fund. And I'm also board president of the Virginia CDFI Coalition. This fund and the work that it was able to achieve in 2021 and beyond has resulted in $6.4 million of lending into the hands of small businesses that were impacted by COVID. It was an emergency response that was much needed. Since that time, we've seen the value. We've organized a group of over 20 loan funds and banks and credit unions that do capital access and economic development work through their financing and banking services. So that is also a result of this pool. It aligns with DHCD's other programs, and so we're very much excited and supportive of this bill and hope to see this fund established permanently in statute. Thank you.
Thank you. Others, please tell us your name and your support, and if you have something compelling to add, please do that.
Yes. Good evening, Mr. Chairman, members of the committee. I'm Kelly Harris Braxton with Virginia First Cities Coalition, and we strongly support this codification of the CDFI fund. It's very important to cities and others, and we strongly support it. Thank you.
Thank you.
Mr. Chairman, members of the committee, Heather Derflinger with the Virginia Bankers Association, and we support this bill. As a member of the Virginia CDFI Coalition, our member banks partner with community development financial institutions, and we support codifying the fund and providing additional funding for the program. We hope you all support this bill. Thank you.
Thank you.
Mr. Chair, Brian Kozul with the Virginia Housing Alliance. CDFI lending is a critical component to the development of affordable housing, and we strongly support the bill.
Mr. Chair, members of the committee, J.T. Blau with the Virginia Credit Union League. We have 105 credit unions in Virginia, 7 are CDFI certified. We support this legislation. Echo the comments of the commenters before me. Thank you.
Thank you.
Mr. Chairman, members of the committee, Joe Lurch with Virginia Association of Counties in support of the bill. Thank you.
Thank you. Are there any in the room in opposition to this legislation? Okay. Do we have any in Zoom on either side?
Those in Zoom who wish to speak to this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay. There was a motion and a second to report and re-refer to finance. All in favor will vote aye on the electronic voting system.
Mamie, you're.
Ayes 14, no 0.
Okay.
Thank you, Mr. Chair.
Thank you, Senator. Senator McPike, you've got some bills for us.
Mr. Chairman, if we could do Senate Bill 1046.
Okay, we'll direct our attention to Senate Bill 1046, you said?
That's correct. Senate Bill 1046 adds the definition of fire marshal to the code section. Adds the definition of law enforcement fire marshals when they're appointed with duties and powers under 27.30. As you see in the same section, campus police officers, animal protection officers, conservation officers, there's many other categories, but right now fire marshals are not included in that, even though under the other section they actually have arrest powers. So we're trying to make sure that we sort of close this portion under 9.1 and close up. It has created some issues in the past in some court cases where there's been a question from the judge in terms of the authority because they're not listed under police law enforcement officer. So it's kind of quirky, but that is one of the closes, one of the fixes we're trying to solve.
Mr. Chairman.
Senator Reeves.
Senator McPike, how is this different from, I think it was Senator DeSaff's, where we're...
Yeah, Mr. Chairman, Senator Reeves, what he was doing was the allotting of retired fire marshals to then come back into the service. It's a different code section, different provision.
Got it. Thank you.
Senator Mason.
So today on the floor, we struck the line that said we'll consider them as police officers on that bill.
For the upper section, but not the lower section of it.
Mr. Chairman.
Senator Mason.
So is the way this is worded, they have police power when they're doing their fire marshal duty and can then arrest, or can they jump in the car, drive down the road, and pull somebody over and arrest? This is understood.
So, Mr. Chairman.
Yes. Sir.
The answer is under 27-30. That's where they derive their authority, and it's by local ordinance that they have specific duties and powers assigned to fire marshals. So the locality has to go through that process of adopting ordinance with very specific, and it's typically related to arson and other things. But there are arrests and felonies. Arson is a felony, right? There are arrests and search warrants and the rest that fire marshals have to pursue with it. So it's a very limited scope under 27.30.
Thank you, Mr. Chairman. Thank you, John.
Okay. Are there witnesses who would like to speak in support of this bill here in this room today? Any opposed to this legislation here today? Any in Zoom want to speak either way?
Those in Zoom who'd like to speak to this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, there's a motion and a second to report SB 1046. All in favor will vote aye. And all who have many proxies will also vote? Okay.
Ayes 13, no 0, 1 abstention.
Okay, and then you have another bill, Senator?
Yes, thank you, Mr. Chairman. Senate Bill 1138. And I do have a substitute.
Okay.
Line amendment. Line amendment.
Okay.
Council saying a line, lip syncing line amendment.
There's a line amendment to Senate Bill 1138. Do you want to, is it substantive or just technical?
If council don't mind.
Thank you, Mr. Chairman. On line 36 of the introduced version after rent, we're inserting, this subdivision shall not apply to any increase in rent that occurs after the first year of a lease with a term longer than 1 year. So it's a limiting provision.
Okay. Senator McPike, do you want to explain the bill to us?
Yeah, thank you very much, Mr. Chairman, members of the committee. So the underlying bill is essentially making sure that there's not a way that rent could increase during that 1 year occupancy. The current amendment that we just did, make sure if you have a multi-year lease, it can still provide except for that 1 year period. And so the issue is there are some subsets actually of light tech and other affordable housing that do allow a provision, oddly enough, for a mid-term increase. And so as talking to the industry, this is not a common thing, but we want to make sure to close it. And we've collaborated on language to get us there. And, think we have some common language to work with this amendment. And I'm not sure if we've adopted it, but that is the sort of technical loophole that we were trying to close.
Okay.
Obviously, you still, Mr. Chairman, you still have provisions that both parties can consent in writing. There's notice and other things. It's just not a unilateral change midterm.
Okay, so let's take up the line amendment first. I think I heard a motion and a second to adopt the line amendment that was just explained. All in favor will say aye. Any opposed? Okay, so the bill is before us as amended now. Basically, you're saying that if you have a rental increase during the term of a previously written lease, that it requires a new document in writing?
No, the enforceability in terms of having a mid-year, we're not allowing that. That's what we're saying.
Okay.
Unless both parties, there's a beneficial thing or something else that both parties agree to, it should be at your next term or your next renewal. Likewise, if you have a multi-year contract, it's according to the terms of those contracts.
Okay. Are there folks in the apartment community or otherwise who'd like to weigh in on this bill?
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We thank the senator for working with us, and we support the bill as amended.
Thank you.
Mr. Chairman, Erin Corman with the Realtors, and we also support the bill as amended.
Great. Thank you.
My name is Marcel Perez, and I support the bill, and I appreciate you. I also wanted to say, having them increase the amount of rent when you don't know whether you are going to be able to eat and stuff like that, and all the other different things that goes on, it's not fair. It's a legal contract. And if I can say, oh, I'm not going to pay you, I can't say that for that month and still be there, but they can say they can raise my rent. This has personally affected me because my rent has went up out of 2 months, 3 times. It escalated. There were no revisions or anything, and also,
So you're in support. Thank you.
yes.
Thank you very much.
Hello, my name is Gustavo Espinosa. I'm with the Legal Aid Justice Center. I'm a Virginia renter myself, and I'm also a tenant organizer with the Legal Aid Justice Center. And I'm here to voice support for this bill as amended. And I just wanted to clarify that I work with a lot of tenants that live in low-income housing tax credit properties, and this is a problem for them. So this is straight out of one of their leases, a special provision that many of them weren't aware of until they started to receive notice after notice saying that their rent was going to increase, even when the renewal of their lease wasn't in question. And this special provision reads, the maximum allowable rental rate for your apartment may be dictated by the administrator of the LIHTC program. Therefore, management, in order to conform to this program, reserves the right to increase the rental rate at any time during the term of the lease with a 60 days notice. This is happening to tenants, it's harming them, and it's not fair. So I urge you to support this bill. Thank you.
Thank you for that information and for being here. Yes.
Christy Marrow with the Virginia Poverty Law Center, and we support the bill.
Thank you.
Hi, Molly Jacobson with the Virginia Housing Alliance, and we support the bill.
Thank you very much. Yes, we've got a question from Senator Donovan.
For the patron, just to make sure I understand, this is not just for the first year, this is for every year of rent. There's no
Correct, unless you have a
mid-year
multi-year
increases.
contract and you have resets at that annual benchmark, yes.
Okay, fair,
And that's what the
great.
amendment helped to clarify.
Good, all right, I just wanted to make sure. Thank you.
Okay, was there anyone in Zoom waiting to speak on this bill?
Those in Zoom who'd like to speak to this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, Senator Mason.
So they said something about to be in accordance with the LIHTC program or something. Is that some requirement? I mean, this doesn't fly in the face of some federal requirement or something, because this is just absurd.
It is absurd.
Do I hear? Yes, Christy.
Mr. Chairman, Senator Mason, the LIHTC rents are based upon a certain percentage of the area median income. So when those go up, they have the option of raising the rent, but they don't have to.
They should do it at the annual, not
Exactly.
in between. And they're doing it in
Exactly.
between.
Exactly.
And sorry, I would just like to add that this bill would stop them from allowing to do that, but also stop them from using that as an excuse. Because we are hearing landlords saying, well, I'm just doing what the program said, I'm raising your rent to what they make me do it. So that's another thing. And then also just to add some idea of the scale, the rents, at least in the jurisdictions that the Legal Aid Justice Center serves, so Charlottesville, Richmond, and Northern Virginia, we're seeing from 2021 to 2022, the maximum rent amounts going up $100, $200. So receiving that notice when you weren't even considering whether you wanted to renew your lease is jarring, and that's not the contract that they believe they entered into.
Thank you. Okay, there's a motion and a second to report SB 1138 as amended. All in favor will vote aye.
Ayes 14, no 0.
And Senator, did you have one more bill?
I do. Senate Bill 1042. And I do have a substitute on this one, Mr. Chairman.
Okay, is there a motion to adopt the substitute?
Second.
Okay, all in favor of adopting the substitute that's being passed out, say aye.
Aye.
Any opposed? Okay, why don't you explain the substitute?
Thank you, Mr. Chairman. The substitute, this bill seeks to make changes to the procedure followed by the CIC Ombudsman for processing notice of final adverse decisions. And so currently a member of the association or citizen, after getting an adverse decision through the association complaint process, can escalate that decision to the Ombudsman for a determination of whether the association violated the common interest community law or not. The bill would give the Ombudsman the power to refer any potential violation of the POA or condo common interest community law directly to the CIC Board for evaluation. The bill also adds language requiring any repeat violation as determined by the Ombudsman that occurs within 365 days of the Ombudsman's initial determination of the violation to be referred to the CIC Board for evaluation. The bill also clarifies when the Ombudsman is directed to contact the association with respect to a final notice of final adverse decision, and she must also contact then the association's governing board and common interest community manager if applicable. And then finally, the bill seeks to add an additional data point to be tracked by the Ombudsman's office, the number of violations that are referred to the CIC board for evaluation. So sorry, there's a couple different components, but it's helping to get a smoother process and use of the common interest community ombudsman and their work product. So that's in summary what the bill is.
Are there questions from the committee members for Senator McPike?
Mr. Chair.
Yes, Senator Boyce, go.
Thank you. I have a question for Senator McPike. So is this intended to protect individuals who live in the community, or is it or to help manage disputes between residents and their HOAs? Is that what is? Can you just repeat the intent again?
Certainly, and I'll probably ask one of our real estate experts here behind this shoulder, if I'm looking in reverse, to answer some of the process. But the ombudsman is the complaint process and the advocate that we have and we've hired, and we have a process to do it. It's really trying to delineate a better notification process and determination and making sure that information exchanges. But please.
Mr. Chair, Senator Boysko, so the Ombudsman office at DPOR that is there to review once a member of an association goes through the complaint process at their association. If they get a decision that they disagree with, they can then contact the Ombudsman, and the Ombudsman will review it to see if they think there's been a violation by the association with common interest community law. Okay.
And are there others who want to testify? Ms. Trigiani, were you weighing in on this bill?
We're in support of the bill. Thank you very much.
So we have agreement.
I'm not sure about
Well, there's pieces.
Okay. Is there anyone else in Zoom who wanted to testify on this bill?
Those in Zoom who wish to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, so there's a motion and a second to report the substitute for SB 1042. This was not on the list for finance, right? Okay, to report. All in favor will vote aye.
Ayes 14, no 0.
Okay, is that I know there was a bill from Senator Barker, but he's not here. He had two bills. I don't know if he's nearby or if were there any other bills before us? Okay, I know that Senator McPike has a meeting scheduled of the subcommittee, so why don't we have a motion to
take
those two bills by for the day? Okay, all in favor of carrying them over will say aye.
Aye.
Aye. Okay, any opposed? Okay. So with that, the full General Laws Committee meeting is over, and the subcommittee on gaming will begin when Senator McPike calls it to order.